Check 1, 2. Good morning. Ladies and gentlemen, good morning. We are about to begin with the program, but before we can start, just some few tips. You'll see the emergency exits on both sides of the auditorium, on the left and the right, marked emergency exit. On our right, on the different exit signs, you have bathrooms, both ladies and gents. On my left, which will be your right, there's a marquee which will serve as a coffee station, coffee and tea station. And at the back of the auditorium, right towards the back, there will also be additional coffee and tea stations. The QR codes in front of you, for those of you who are not using Alcatel and Nokia 1065, you can use those QR codes with your smartphones for the program. So there's a digital updated program which may not necessarily look the same as the program that has been printed. You can use the QR codes for the program. With regards to cell phone, the general rule again is that let's try and have our cell phones on silent mode. If that is not possible, we can put them on flight mode. I think that will help us a lot as we move along. The sound of cell phones might be very disturbing, so we make a request that we put them on silence mode, or we put them on flight mode, at least for the duration of the session until the tea break. That's all for now. We'll start with the program very soon. There are just a few things that we are quickly finalizing. Thank you very much. you indicate to me when it's there. So I must tell them. Okay, ladies and gentlemen, may I please call the conference to order, please? May I please call the conference to order? The head of state is about to arrive. May I request that we take to our feet to receive the president? Mr. President, you are welcome. You may have a seat. Honorable President, His Excellency Cyril Ramaphosa, Honorable Speaker of the National Assembly, Honorable Nosiviwe Mapisa Ngakula, the Honorable Chief Justice, Raymond Zondo, Honorable Minister for Justice and Correctional Services, Minister Ronald Lamola, delegates to the conference, you are welcome. For this moment, I will request that we all rise for the singing of the national anthem. Before we sit, may I request that we observe a moment of silence in honor of our heroes and heroines of our struggle in democracy. Thank you. Mr. President, you may be seated. My name is Doc Mashabane, the Director General of the Department of Justice and Constitutional Development. I will be the Program Director for the day. Before we proceed, we have a short video to play on the screens. May I request that we activate the video? Thank you very much.
How do we attain our freedom? That's what we have to ask. remains for us the only open door for progress. We formed the South African Native National Congress, later called the ANC, along with others like the Bantu Women's League and the ICU. We saw the people rose like a wave, an ocean. We wrote a Bill of Rights, a set of laws for a land where all people are equal and can vote. The white rulers banned communists and created inferior schooling for black children. Separate areas were created for black and white with passed laws that restricted the people's movement. And still, we the people cried, my ooh, yeah, Africa, freedom in our lifetime. The Congress of the People gathered demands from across the beautiful living land. A bold new political party was formed by a teacher. It was called the Pan-Africanist Congress, the PAC. At a police station in Sharpeville, the people protested against past laws. The police raised their guns. Shots clattered into the air as the protesters fell. The nation reeled. White South Africa cut ties with the rest of the world, and the land became a republic. Resistance went underground. Many activists fled into exile and into Africa to rally support and receive military training. The people took up arms. Revolution seemed like the only way. The leaders of the ANC were captured in Livonia and put on trial for their lives. The regime boasted that it had broken the back of the resistance struggle by sending our leaders to prison. Generation after generation stood up to demand that freedom would one day crash onto the shore. The stars had realigned at last. All South Africans had voted. Political prisoners and exiles. A final draft of the Constitution.
Refuse to accept that our Africans shall be defined by our race, our color, our gender, or our historical origins.
Now the Constitutional Court had to certify it. They sent the text back to the Constitutional Assembly for corrections before they were satisfied. There was jubilation, a final constitution at last. At a stadium in Sharpeville, after 350 years of struggle, the president signed the law for our new country. Our Constitution gives us the map for the way forward. On its own, it doesn't stop corruption, it doesn't build schools, homes, or hospital beds. But if we, the people, continue to roll up our sleeves, we can make the constitutional dream our reality. Our dreams and struggle for freedom continue.
Thank you very much. Ladies and gentlemen, I want to take this opportunity to welcome you here to the National Conference on the State of Human Rights in South Africa, 3 decades of respect for and protection of human rights. I want to take this opportunity to invite the Minister for Justice and Correctional Services to come and give an opening and a welcome address. Honorable Minister, I invite you.
Thank you very much, Director General Advocate Mashabane, His Excellency, the President of the Republic of South Africa, Matamela Cyril Ramaphosa, the Chief Justice of the Republic of South Africa, Justice Raymond Zondo, and all the Judge Presidents of our courts who are present here today, the Speaker of the National Assembly, the Chairperson of the National Council of Provinces, my colleagues in Cabinet, Ministers and Deputy Ministers who are present here today, the SADC Ministers of Justice who are present here today, the Chairperson of the African Commission on Human and People's Rights, Honorable Commissioner Rem Ngoyi Lumbu, the United Nations Commissioner for Human Rights, Mr. V. Turk, the chairpersons and members of the United Nations treaty bodies dealing with human rights, including former South African members of the treaty bodies, members of the Diplomatic Corps, the House Chairperson of committees in the National Council of Provinces, members of the National Assembly and the National Council of Provinces who are present, premiers and executive mayors, members of parliament, academics, human rights activists, civil society, the chairperson of the South African Human Rights Commission, the chairperson of the House of Traditional Leaders and other traditional leaders present, university vice chancellors, and other director generals who are here, and all state officials and leaders of NGOs and other structures in our society. Distinguished guests, ladies and gentlemen, members of the media, the year 2024 marks a significant milestone in our country's constitutional democracy, 30 years of progress and growth. The Department of Justice and Constitutional Development, as the guardian of our Constitution, has taken the initiative to host the National Conference focusing on human rights in South Africa, under the theme, 3 Decades of Respect for and Promotion for Human Rights. This conference aims to reflect on our journey towards equality and justice. It's aimed to re-invoke the spirit of freedom fighters, who some of them are here today, but also as a reference for cross-pollination with the younger generation to plot the future of our democracy. It is crucial to remember the sacrifices made during the struggle against the oppressive apartheid regime. The tragic events at Sharpeville and Langa serve as a stark reminder of the brutality faced by the freedom fighters. Ourselves, as the younger generation, have got this opportunity to engage, reflect, and plot the future, like freedom fighters did during CODESA. The peaceful protest against apartheid laws, the violence inflicted on innocent protesters, and the global outrage that followed also shaped our nation's history and commitments to human rights. As we commemorate the Human Rights Day on the 21st of March, let us honor the memory of those who fought for our democracy, and at last reaffirm our dedication to eliminating all forms of discriminations and injustice. Our country's transitions from a diverse past was done through the Constitution of the Republic of South Africa in 1993, an interim constitution which had the objective of ensuring a non-violent transition and to ensure reconciliation within our country. Its preamble provided for the creation of a democratic and a constitutional state in which there is equality between men and women and all races, and all citizens shall be able to enjoy and exercise their fundamental rights and freedoms. Chapter 2 of the 1996 Constitution contains the Bill of Rights, which is the cornerstone of South Africa's human rights framework, a commitment to build a culture of human rights and to reverse the centuries of gross violations of human rights, inequality, and indignity suffered by the majority of the population. In his address to the Constitutional Assembly on the occasion of the adoption of the 1996 Constitution on the 8th of May 1996, former President Mandela clearly articulated the obligation and commitment, stating that, and I quote, "The new Constitution obliges us to strive to improve the quality of life of the people. In this sense, our national consensus recognizes that there is nothing else that can justify the existence of a government without the will of the people. This government must justify its existence through redress of centuries of unspeakable deprivations by striving to eliminate poverty, illiteracy, homelessness, and diseases." In the 2024 State of the Nation address, President Ramaphosa re-emphasized the point when he said, and I quote, "It is in this Constitution that has guided our collective efforts over the last 3 decades to fundamentally change our country for the better, and it must stand at the center of the work we do now to build a life for all. Just as we cannot deny the progress South Africans have made over the last 30 years, nor should we diminish the severe challenges that we continue to face." Close quote. The core essence of our constitutional democracy is anchored on the need to ensure an improvement in the quality of life for all and to unlock the potential of each person. We all have a role to play in building this country and its future. This was best articulated by the former Chief Justice Pius Langa in his 2006 speech on the nature of a transformative constitutionalism. He stated the following, and I quote, "Transformation is not a temporary phenomenon that ends when we all have equal access to resources and basic services, and when lawyers and judges embrace a culture of justification. Transformation is a permanent ideal, a way of looking at the world that creates a space in which dialogue and contestation are truly possible, in which new ways of being are constantly exploited and created, accepted and rejected, and in which change is unpredictable, but the idea of change is constant." Close quote. It is in this context and this spirit that we convened this conference, Mr. President. Seated here are South Africans, members of international bodies that have also are continuing to play a role in human rights across the globe. We have got friends and foes, enemies, and everyone in our country who are here wanting to chart a way forward. They all subscribe to the Constitution and believe in the future of our country. We have also in the past 30 years always played a role in human rights across the globe and also in multilateral institutions. We have also been in the forefront for human rights and for self-determination for the people of Western Sahara and also for the people of Palestine. Here seated are people who are ready to engage for the next 3 days to chart a way forward. And it's not just a mere talk show, Mr. President, because we now want to bring into reality what is contained in Section 9 of the Constitution, to mainstream equality in every legislation and everything that government does, and also what the private sector, NGOs, and everyone in our country does. It is a festival of ideas, similarly to the one you had, CODESA. Unfortunately, ourselves, because of biology, we're not there. But we see this one as our own CODESA. Mr. President, we now invite you. We will now invite you after the Speaker and also the Chief Justice to engage also with the audience with a clear aim to also unpack your own experiences and also to chart the way forward for our country. And now, thank you very much, Director General.
Thank you very much, Minister. And for those of us who were not there, you have already spoken for us. It's not because of cowardice that we couldn't be there, but it was for biological reasons that it was just not possible for us to be there. Ladies and gentlemen, we proceed with the program. And now I want to take the opportunity to invite the Honorable Speaker of the National Assembly, who is here also accompanied by the Chairperson of the National Council of Provinces, Honorable Amos Masondo, but there's the Speaker of the National Assembly, Madam Nosviwe Mapisa Ngakula. I invite you to the podium. Ma'am.
Thank you very much, Program Director. I was just hinting to the President that old age is not good. I lost my spectacles, I was cleaning them, and when we took the floor, when we stood to sing the national anthem, I lost them. Now I found them again. Thank you very much, Program Director. The President of the Republic of South Africa, His Excellency Cyril Ramaphosa, the Chief Justice Raymond Zondo, Minister Ronald Lamola, ministers and deputy ministers, heads of institutions supporting our democracy, invited guests and panelists, ladies and gentlemen. We thank you, Minister Lamola, for the invitation to be at this important conference as we extend our support on behalf of the entire legislative sector. We also thank you and the Department of Justice for hosting this important conference that serves to celebrate a great legacy for our freedom, as well as to make a frank assessment of the extent to which we are succeeding in translating the rights enshrined in our Constitution. Although this year we formally mark 30 years of freedom, democracy, and an institutionalized culture of human rights, we also know that our people have always yearned and fought for justice and human rights for much longer, since the very beginning of colonialism and racial oppression in our country. It's in fact this love and commitment to justice, equality before the law, and the right of all individuals to be treated as part of humanity that led our forebears to engage in the struggle for freedom in the first place. So as we celebrate what we have achieved in the past 30 years through democracy, we also celebrate this commitment and of over a century-long struggle by those before us who made it possible to earn our freedom and liberties as we celebrate them today. President, in December 1943, as you are a president of the African National Congress, in addition to being a president of the Republic, you'll recall that the National Conference of the African National Congress adopted the African Claims, the very first formal articulation of what was later to evolve into today's Chapter 2 of our Constitution, the Bill of Rights. In it, they articulated the aspirations of the African people in South Africa, their undisputed claim to full citizenship, and their desire for all classes, colors, and races to have and fully participate in the educational, political, and economic activities of their country as equal citizens. In its preface, the then President General of the ANC, Dr. Kluma, summarized the obtaining reality for Africans as this, and I quote, "In South Africa, Africans have no freedom of movement, no freedom of choice of employment, no right of choice of residence, and no right of freedom to purchase land or fixed property from anyone and anywhere. Under the guise of segregation, they are subjected to serious educational, political, and economic disabilities and discriminations, which are the chief causes of their apparent slow progress," close quote. We can then confirm that for our people, the struggle for freedom was not just about being freed from bondage, but about obtaining their rights and liberties. It has always been an aspiration of all our people in this country that each one's individual's potential can be harnessed and fulfilled for the benefit of both themselves as well as the country. We are now almost 81 years from the time of the adoption of the African Claims. And since then, we have seen the adoption of the Freedom Charter in 1955, and finally our Constitution of a Democratic South Africa in 1996, all as a legacy that began with the accession of the African Claims. Having faced the dark shadows of our ugly past, South Africans have showed resilience, courage, and unwavering commitment, fighting to dismantle that past and paving the way for a democratic era founded on the principles of equality, freedom, and dignity for all. In the face of adversity, South Africa and many African nations have also shown great resilience and progress in advancing human rights under democracy. The establishment of constitutional democracies, independent judiciaries, and vibrant civil societies have paved the way for greater legal protections and advocacy for human rights. The tireless efforts of activists, non-governmental organizations, and ordinary citizens have been instrumental in shaping a more rights-conscious society that strives for justice and equality. Now, one of the key challenges, Mr. President, is the persisting economic inequalities that disproportionately affects marginalized communities, including Black South Africans, women, and those who are living in deep rural areas of our country. Despite policies aimed at addressing historical disparities, the legacy of apartheid continues to cast a long shadow over the country's economic landscape, with wealth and opportunities still concentrated in the hands of a few. High levels of unemployment, particularly amongst young people, exacerbate economic inequalities and hinder the full enjoyment of economic rights for many South Africans. Limited access to quality education and skills development further restricts economic opportunities, perpetuating cycles of poverty and social exclusion. The recent effects of COVID-19, Mr. President, compounded the situation further as it exposed and deepened existing economic inequalities in South Africa. The biggest brunt of this economic fallout was mostly felt by the vulnerable populations. Later on, you were to name the gender-based violence as the second pandemic, Mr. President. And indeed, we all agree as South Africans that violence against women or gender-based violence is indeed a second pandemic in South Africa. Now, recognizing women's rights as human rights is a critical and ongoing struggle that continues to be relevant even as we celebrate 30 years of freedom and democracy in South Africa. Despite considerable progress in the past few decades, women in South Africa still face a myriad of challenges that hinder their full enjoyment of their rights. One of the significant challenges that women continue to face is this gender-based violence. Mr. President, in the past week I was at the UN, and the issue really was about gender-based violence. You will hear from the delegation which was led by Minister Zulu. You will receive a report. South Africa has one of the highest rates of gender-based violence in the world, with women and girls often being subjected to physical, sexual, and emotional abuse. This pervasive issue not only violates women's fundamental human rights, but also perpetuates a culture of fear and silence that further marginalizes them. The other challenge is the persistent gender wage gap and limited economic opportunities for women. Despite legal frameworks that promote gender equality in the workplace, women in South Africa are still paid less than their male counterparts for the same work. Women in South Africa continue to experience limitations in their reproductive rights and access to quality health care. High rates of maternal mortality, limited access to contraceptives, and inadequate health care services disproportionately affect women, especially those living in rural areas and informal settlement. But I do want to congratulate you, Mr. President, on behalf of Parliament, for the 2 gender summits which you have had, which you have convened, which came out with a declaration that talks to a deep, deep-seated commitment for all of us as South Africa to fight the scourge of gender violence. So as we commemorate the 30 years of freedom and democracy, it is crucial to reaffirm our commitment to advancing women's rights and empowering women to fully participate in all aspects of society. Only through collective action and sustained advocacy can we create a more just and equitable society where women are truly able to exercise their rights and live free from discrimination and violence. For our part as the legislative sector, we have continued to strengthen our oversight and monitoring capacity to ensure impact on all the policies that we've enacted to give practical expression to the Bill of Rights. These include, but not limited to, the strengthening of the gender-responsive budgeting mechanisms in passing and monitoring our budgets. Chair, as I take my seat, as we reflect on 30 years of democracy, it is crucial to recommit to building a more just and inclusive society where economic rights are upheld and all citizens can thrive and contribute to the country's progress and prosperity. Once again, we wish for this conference to be a productive and impactful one. I thank you.
Thank you very much, Madam Speaker. Of course, one of the greatest honor you can bestow on any individual is to have a Speaker of the National Assembly call you chair, and which is what she just called me now. Ladies and gentlemen, we proceed with the program. I have the singular and exclusive honor now to invite the Chief Justice of the Republic of South Africa, Honorable Raymond Zondo, to the stage. Chief Justice, you are welcome.
Tall people always put this higher, and then we short ones have to pull it down. Thank you very much, Program Director, Director General of the Department of Justice and Correctional Services, Your Excellency, Mr. President, Speaker of the National Assembly and Chairperson of the NCOP, heads of court present here and other judges of various courts, ministers, deputy ministers, heads of other state institutions present here, distinguished guests, ladies and gentlemen. I thought that in the few minutes that I have been given, I would talk about our courts, our defenders of the Constitution. I feel honored and privileged to have been invited to give a message of support to this very important conference, whose theme is 3 decades of respect for and promotion of human rights. I take this opportunity to congratulate the Minister of Justice and Correctional Services and his department for convening this very important conference, so that as a people when we reach a milestone such as 3 decades of democracy, we could reflect on the journey that we have traveled so that we can prepare to make sure that the journey starting after the 29th of May, the journey of the 4th decade of our democracy, can be a much more improved journey. I thought that when we have a conference such as this, it is important that the 3 arms of state, in a way, report back on some of the things they have done to promote and show respect and defend human rights. Of course, the judiciary is at the center of the promotion and defense of our human rights. Our Constitution begins in Section 1 by announcing to the world who we are as a state. It says we are one sovereign democratic state founded on the following values: human dignity, the achievement of equality, and the advancement of human rights and freedoms, non-racialism and non-sexism, supremacy of the law and the rule of law, universal adult suffrage, a national common voters' roll, regular elections, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. That is who we are. In terms of Section 2, our Constitution proclaims the supremacy of the Constitution and says, and I quote, "The Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled." In Section 38, our Constitution goes on to confer on the courts that are competent to enforce and defend the fundamental rights in our Bill of Rights, the power to grant appropriate relief, and allows anyone listed in that section to approach the courts when they feel that their fundamental rights have been violated, and it says the courts may provide relief. Our courts over the past 30 years have done exactly that. When they have found that fundamental rights entrenched in the Constitution have been violated in specific cases. All of the rights that are set out in our Bill of Rights can be enforced in our courts. However, the courts, in order for them to be able to properly protect and defend these fundamental rights, require to have adequate judicial officers, require to have adequate resources, and require to be able to operate in an environment that allows them to ensure that they can administer justice expeditiously. Of course, we accept that the courts in South Africa cannot be in a perfect situation because resources are always limited. But it is important that those who feel that their fundamental rights have been violated and who take their disputes to our courts are able to have their cases heard and decided reasonably quickly. Because it will be unacceptable, and it is unacceptable when justice is delayed for too long. One of the new structures of our constitutional democracy that was introduced into our legal system by the interim constitution of 1993 was our Constitutional Court, which was initially placed at the same level as the Supreme Court of Appeal, but was later made the apex court of our country. It was established as the highest court which would decide matters concerning the Constitution and therefore matters concerning violations of human rights. It is the highest guardian of our Constitution, which is why the original final Constitution of the country that was signed by President Mandela is kept at the Constitutional Court. It is appropriate when we reach this milestone that we look at least some of the ways in which our courts have made a difference in the lives of our people. In particular, the Constitutional Court, which, as I've said, is the upper guardian of our Constitution. Therefore, within this time that is allocated, one will refer to some cases which have made practical difference in the lives of people that our courts, particularly the Constitutional Court, have decided. This is important because as long as people do not see any change for the better in their practical lives, despite the existence of a constitution that has these wonderful fundamental rights, they will have no respect for the Constitution. The Constitution was enacted in order to ensure that this country and this republic is a better country, much better country than it was before 1994. But in order for it to be a much better country, the lives of the people must improve and be better. The second case which the Constitutional Court had after its establishment was the Makwanyana case, in which the Constitutional Court outlawed the death penalty. Although from time to time one hears people who call for the return of the death penalty, it seems to me that overall that decision was accepted. That decision effectively introduced our Constitutional Court to the world and to the family of Constitutional Courts worldwide. It is a decision which will never be forgotten because it had such an impact on our society. Of course, many people on whom the death penalty was imposed and who were executed were overwhelmingly black people. And that decision assisted to make sure that lives will be saved. At the height of the HIV/AIDS, when many people were dying because of HIV and AIDS, it was to the courts that the Treatment Action Campaign turned for the enforcement and protection of the right to have access to healthcare services and every child's right to basic healthcare services, entrenched in Section 27(1) and 2 of the Constitution, respectively. When the court started its judgment in that case, it did so in the following terms which reflect on how dire the situation was, and I quote, "The HIV/AIDS pandemic in South Africa has been described as an incomprehensible calamity and the most important challenge facing South Africa since the birth of our democracy, and government's fight against this scourge as a top priority," close quotes. In that case, the Constitutional Court, among others, ordered government to remove the restrictions that prevented nevirapine from being made available for the purpose of reducing the risk of mother-to-child transmission of HIV at public hospitals and clinics that were not research and training sites. The court also ordered government to permit and facilitate the use of nevirapine for the purpose of ensuring that people were saved and children did not easily get the HIV transmitted to them. That was a judgment which affected the lives of many people during that time. Now that HIV/AIDS is no longer such a big issue, we might forget how important that judgment was. And I think it is important that on this occasion, when we look back at the journey that we have traveled, we remember that time and remember what a difference that judgment made. Of course, there are many judgments which the Constitutional Court and other courts have given over the past 30 years, which have changed the lives of the people of South Africa and different sectors. But within the time available, one can only choose a few and talk about a few. In this regard, I want to refer also to another judgment of the Constitutional Court which really affected and improved the conditions of women who are married according to customary law, namely, as well as girl children, in relation to the African customary law of succession. The Constitutional Court made a pronouncement that made customary law consistent with the right to equality and thus removed discrimination against women and girls. It has abolished the discriminatory principle of male primogeniture in the context of customary law. It also ensured that when a man who has a wife or wives married according to customary law wants to take a second or third or fourth wife or additional wives, he must obtain the consent of the existing wives. This seeks to ensure that their right to equality, the right of women to equality in that situation, is protected and respected. In that case, the Constitutional Court said, and I quote, "The principle of primogeniture also violates the right of women to human dignity as guaranteed in Section 10 of the Constitution, as in one sense, it implies that women are not fit or competent to own and administer property. Its effect is also to subject these women to a status of perpetual minority, placing them automatically under the control of male heirs simply by virtue of their sex and gender. Their dignity is further affronted by the fact that as women, they are also excluded from interstate succession and denied the right which other members of the population have to be holders of and to control property. To the extent that the primogeniture rule prevents all female children and significantly curtails the rights of male extramarital children from inheriting, it discriminates against them too. These are particularly vulnerable groups in our society which correctly places much store in the well-being and protection of children who are ordinarily not in a position to protect themselves, in denying female and extramarital children the ability and the opportunity to inherit from their deceased fathers. The application of the principle of primogeniture is also in violation of Section 9(3) of the Constitution. The primogeniture rule, as applied to the customary law of succession, cannot be reconciled with the current notions of equality and human dignity as contained in our Bill of Rights. As the centerpiece of the customary law system of succession, the rule violates the equality rights of women and is an affront to their dignity. Not only did that also affect large sections of our society and vulnerable groups, but also the Constitutional Court has also touched on the lives of workers in our country, where prior to 1994, an employer wanted to sell his or her business to another one and transferred that business as a going concern to the purchaser, workers would lose their jobs. And the lower court interpreted Section 197 of the Labor Relations Act, which deals with transfers of business as going concerns, to mean that the consent of the seller and the purchaser were required, otherwise the workers would not go with their business. The Constitutional Court intervened to protect the right of workers to fair labor practices, which is entrenched in our Constitution, and concluded that when a business is sold and transferred from one person to another as a going concern, all the workers go with it. And in that way, the Constitutional Court ensured that large numbers of workers who always used to lose their jobs when such transactions happened between business people would no longer lose their jobs. That is what the Constitutional Court intervened and made sure happened in that case in the context of Section 197. Of course, the Constitutional Court has upheld the rule of law in many cases, too many to mention, which many of you here are aware of. The Constitutional Court has ensured that Parliament and the executive, when they go outside of the Constitution, are reined in so that we all act in accordance with the Constitution. When we finish or complete 30 years of constitutional democracy, we have got not only to look at the journey that we have traveled, we also have to look at the journey ahead. And we have got to ask the question, in what way can we be better prepared to face the journey ahead? And as the judiciary, we are clear that we need stronger independence of the judiciary. There is absolutely no doubt in my mind that when it comes to the personal independence of the judiciary, we in South Africa have the personal independence of the judiciary. I have finished 27 years on the bench, and not once have I ever had any minister, president, or official phone me or ask for a meeting to discuss how a particular case should be decided. But we have serious challenges when it comes to institutional independence. That is the challenge that we need to face. Fortunately, the President and I have begun discussions aimed at making sure that the institutional independence that is contemplated by our Constitution will be conferred on the courts, because courts that have institutional independence are in a better position to defend, protect, and promote the fundamental rights. As things stand, the judiciary is ready to go into the fourth decade of our democracy, determined more than ever before to play its rightful role. Despite the fact that for performing its duties the way it is supposed to, it is sometimes put in difficult positions because insults are held at the judiciary when they have done nothing wrong but just do their job properly. Indeed, I have no doubt that if more resources are also made available to the judiciary will play its role in the fourth decade of our democracy even better. With these words, I congratulate you, Minister of Justice and Correctional Services, and your officials for convening this conference so that we could reflect. One wishes that we had more time when we could talk more on the role and the contribution that the three arms of state have made over the past 30 years in promoting, respecting, and defending our human rights. Thank you.
Ladies and gentlemen, may we give the Honorable Chief Justice another round of applause. Thank you very much, Honorable Chief Justice. Indeed, the judiciary, under your leadership and that of your predecessors, have acted over the past 3 decades as vanguards and protectors and defenders of our Constitution and the Bill of Rights in particular. Ladies and gentlemen, at this moment, as the Program Director, I would like to yield to the Minister for Justice and Correctional Services to come and handle an item that I'm not fit to handle. Honorable Minister.
Thank you very much, DG Advocate Mashabane. I now invite His Excellency, the President of the Republic of South Africa, to give us a keynote address. Thank you very much.
Thank you. Program Director, Director General of the Department of Justice and Correctional Services, Minister of Justice, who is the convener of this conference, who we thank for having had the vision and the money, I guess, to convene this conference. When he first mooted the idea of this conference, I thought it was just going to be a get-together of some 50 people or so. And when I approached this hall and I said, how many people are here? He said, more than 1,000. I asked him, do you have the money to convene such a conference? He says he has. So we thank him and his department for convening this conference. Speaker of the National Assembly, Ms. Mapisa Ngakula, Chairperson of the National Council of Provinces, Mr. Amos Masondo, Chief Justice
of our Constitutional Court, Justice Raymond Zondo, Constitutional Court justices who are here present, judge presidents, and members of the judiciary and the magistracy who are also part of this conference, representative of constitutional bodies that are enshrined in Chapter 9 of our Constitution, members of the legal fraternity, traditional leaders who are here present, members of parliament, and I guess I did say ministers and deputy ministers as well, and also importantly, representatives of international bodies who have taken time out to be with us at this very important conference. I saw former ministers who are here as well, and former premiers who are here present, and current serving premiers, and officials of government, guests, and ladies and gentlemen. It is indeed for me an honor to be part of this conference, which is a reflection on 30 years of the promotion of and respect for human rights in our country. The adoption of our Constitution with its Bill of Rights by the Constitutional Assembly on the 8th of May in 1996 was a great moment in our struggle to achieve a free and equal society. As I said at the time, that moment marked the day our country and our people came of age. I referred to the adoption of our Constitution as the birth certificate of our nation, for hitherto we were not even a nation. We didn't even have a birth certificate. So the Constitution forged us into a nation, and we were then given a birth certificate. On that occasion, we proclaimed to the world that we are a society that is committed to democracy, to the rule of law, and to the protection of human rights. The Constitution came to be as a result of great many sacrifices by many people in our country, and in many other countries. Many people sacrifice a great deal in various countries around the world, some being arrested for supporting our struggle, some being killed and maimed for supporting our struggle. And today we honor those people, those in our country who suffered long jail terms, death, maiming, being banished. We honor them and we thank them for the struggles that they waged to build this nation. Before the advent of democracy, our country was defined by racism, segregation, and discrimination. The country's black majority were deprived of many of their rights, such as their land, their assets, their freedom, and their basic human rights. Apartheid tore the social fabric of our communities apart as it violated and degraded the basic humanity of many of our people through humiliation and oppression. Families were broken up as heads of households had to leave their families and children behind to work in the mines or to move to towns to earn a livelihood. Generations of children were denied the right of having the presence of one or both parents as they grew up with their parents working far away. And that was a violation of the United Nations Convention on the Rights of Children. Our indigenous and customary legal systems were upended. They were suppressed and dismissed as harmful, backwards, uncivilized, and savage. Given all these destructive effects, the negation and the denial of the human rights of millions of people, we can be justifiably proud of how far we have come in advancing our constitutional human rights-based order over the past 30 years. As the former chairperson of the Constitutional Assembly that steered the drafting of the Constitution of our country, it is for me a privilege to be here to reflect on the state of human rights in our country. Former Premier of Mpumalanga, Matthew Sposa, whom I saw earlier, was one of those who participated, and many others who are here today in the drafting of that constitution. Since 1994, we have prioritized the advancement and the fulfillment of the Bill of Rights as a cornerstone of our democratic order. Human rights are the basic rights that all human beings should have. Human rights embody the key values of our society, such as equality, dignity, and fairness, and they also define our nationhood. The Chief Justice, in presenting his address to us, took us back to the really opening chapter of our Constitution, which sets out the words that define us. And he said, this is who we are. It is this nationhood that was built arising from our Constitution and clearly articulated by the rights that are embedded in there. Human rights should manifest themselves through protection for vulnerable groups, freedom of speech and expression, religious freedom, the freedom to love whoever you want to love, and other rights that promote the well-being of people. Certainly, there have been challenges and shortcomings over the past 30 years, and we have a long way to go towards completely fulfilling the promise that is set out in our Constitution. And Chief Justice, you're absolutely right. It would have been apt for the three arms of the state to present a report on how far we have gone in the past 30 years to advance the rights of ordinary South Africans. But in a way, you have done so in outlining to us how the judiciary, the defender of the rights that are embedded in our Constitution, has gone about its work. And taking a leaf from what you outlined, I will also touch on some of the areas that the government has embarked upon to advance these important rights that our people have. That said, we should not shy away from the immense progress that we have made. The Bill of Rights enjoins the democratic state to the government largely to enact various pieces of legislation to promote human rights between and among people. Among those we have put in place are the Promotion of Access to Information Act, which gives effect to Section 32 of the Constitution, the Promotion of Administrative Justice Act, which gives effect to Section 33, and the Promotion of Equality and Prevention of Unfair Discrimination Act, which gives effect to Section 9. To give effect to Section 9(2) of the Constitution relating to the measures of redress for previously disadvantaged people in our country, we passed the Employment Equity Act. We also passed the Broad-Based Black Economic Empowerment Act and other such legislation to promote equality, full equality when it comes to opportunities, to the economy and many other areas of South Africans. And in this, I must enjoin our legislature that it is the government having initiated these legislative pieces and with the legislature, as the Speaker said earlier, that has led the process of enacting those laws. Our constitutional order is premised not only on building a non-racial society, but also a non-sexist society. Over the past 30 years, there have been significant changes in the position of women across society, a matter that you, Speaker, spoke about so eloquently in your address. Today, there are more women serving as leaders in both public and private sectors, something that was unheard of in the past, meaning that the rights of women, and of course of black people in general, were so seriously suppressed in our country. In the new dispensation, that is no longer the case, as we are advancing and protecting the rights of women in our country. We have passed a broad range of laws to protect women from all forms of abuse and to advance their rights as well. These include laws around domestic violence, sexual abuse, sexual harassment, and workplace discrimination. If we didn't know, the abuse of women is a violation of a basic right that the women of our country should enjoy and should have. Later this month, on Human Rights Day, we will commemorate the Sharpeville massacre, where unarmed protesters who took a stand against the past laws of the day were mercilessly killed by the apartheid regime. In a far cry from the days of influx control and the hated past laws, in South Africa today, every citizen enjoys the right to free movement. To promote accountability and responsiveness and openness, we have established various institutions to strengthen democracy in our country. And these include institutions such as the Human Rights Commission, the Office of the Public Protector, the Commission for Gender Equality, and others. The judiciary, in the end, is the ultimate protector and defender of the human rights set out in our Constitution. And the establishment of the Constitutional Court, as you said, Chief Justice, as the defender of anyone who, in terms of Section 38, feels that their right has been infringed, ushered in a new era of accountability and respect for dignity. Before the advent of democracy, our country was a pariah state that was infamous for violating the basic rights of the majority of its citizens. We frankly lived in a country where racial discrimination was at the core of government policy. Today, our country is revered as a country that upholds, protects, advances the basic rights of the people who live in South Africa. Following our country's admission as a fully fledged member of the Community of Nations, the democratic state has signed, ratified, and acceded to various international human rights law treaties. The many treaties we have signed and ratified and acceded to deal, amongst other things, with economic, social, and cultural rights and the elimination of racial discrimination and all forms of discrimination against women as well. They include conventions on the rights of the child, conventions against torture, and other cruel, inhuman, degrading treatment. They also include conventions that protect the rights of working people. Alongside our Constitution, these treaties bear testimony to the fact that our democratic government is irrevocably committed to respect, to protect, to promote, and to fulfill the rights of our Constitution. It is a joy to us that we have a judiciary that is irrevocably committed to defend, to protect the basic human rights of our people. And we have a legislature that is also irrevocably committed to pass laws that will always seek to advance the rights of South Africans without degrading them. A legislature that will always be on the side of the vulnerable, the side of those whose rights need to be advanced. Not only are we committed to the rights of all in our country, we are also committed to global peace and will fight all forms of oppression and the violation of the rights that many other people around the world also ought to enjoy. In January 2024, South Africa appeared before the International Court of Justice as an applicant against the State of Israel on the grounds that through its conduct in Gaza, Israel violated the Convention on the Prevention and Punishment of the Crime of Genocide. At the heart of South Africa's case is the blatant violation of the human rights of Palestinians by the State of Israel. Having noted that the Genocide Convention was the first human rights treaty that was adopted by the General Assembly of the United Nations on the 9th of December in 1948, an act which signified the international community's commitment to the respect of human rights of all. We felt, as South Africa, duty-bound to support the cause of the Palestinians in their quest not only for nationhood, but also to have their basic human rights protected, respected, and advanced. And in doing this, we remembered the efforts and the sacrifices that were made by many people around the world who, on seeing how South Africans were engaged in their own struggle to have their human rights respected, protected, and advanced, felt that they should join issue with us. And these were people who had never even come to South Africa, visited South Africa at all. But they were moved by the human spirit to support our quest for human rights. And it is this that too has motivated us to support the people of Palestine. And this we do following the words of Nelson Mandela, who said, "Our own freedom, a freedom that was really about human rights, will never be complete until the freedom of the Palestinians is achieved." The International Court of Justice ordered several provisional measures, including that Israel must take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Genocide Convention. These acts include the killing or causing serious bodily harm or mental harm to Palestinians in Gaza. While the court still has to hear South Africa's main application, the provisional measures that it ordered has reaffirmed the centrality of international law and the responsibility we all carry for the protection of the rights of all. Our commitment to advancing the human rights of our people and other people in other parts of the world should motivate us to address the challenges that many still face in having their basic human rights recognized and advanced. To quote Madiba's words, overcoming poverty is not a gesture of charity, it is an act of justice. It is the protection of a fundamental right, the right to dignity, and the right to a decent life. The social protection measures we have put in place to lift our people out of poverty have made a tremendous difference over the past 30 years. However, much more still needs to be done. The social protection measures we have introduced do go far beyond the provisions of grants for the elderly, the children, people with disabilities, as well as military veterans, people who fought for the freedom that we now enjoy. It goes beyond the work of the Unemployment Insurance Fund, which provides income support for unemployed workers, or the Compensation Fund, which supports those involved in workplace accidents. Our social protection measures include spending up to 60% of our country's budget on a significant social wage, expended on healthcare services, free water, electricity for the indigent, fee-free schools, public housing, school nutrition, early childhood development, and expanded financial support for students. These measures have contributed significantly to fulfilling the most basic human right of all, namely the right to dignity. Certainly, we know that social protection is no substitute for decent work. It is our role as government, working in partnership with business, with labor and civil society, to create an enabling environment for more jobs and opportunities to be created, allowing our people to fulfill their potential and to improve their lives. We also know that our progress continues to be hindered by delays and lack of diligence on the part of government entities in fulfilling their constitutional obligations. We continue to be plagued by poor service delivery, especially in our municipalities. Corruption deprives citizens of the fulfillment of their rights. While we are rightfully proud of how far our constitutional rights-based order has come, we know that much more still needs to be done to fulfill the promise of the full enjoyment of the basic rights of all our people. The creation of employment for our people and promoting the rights that are enshrined in our Constitution are necessary to improve lives and to lift millions out of poverty and despair. We are therefore duty-bound, and not just as government, but as all of us who have a stake in the future progress and prosperity of this great country, to work harder, sparing neither strength nor courage to fulfill the basic rights of our people. The South Africa of today is vastly different from the place that it was 30 years ago. The fundamental freedoms that were denied to so many, including the heroes who lost their lives at Sharpeville, are enjoyed by many South Africans today. We accept that much more still needs to be done, as I've said, to give full fulfillment. We have expanded access to basic services and education, improved our nation's health outcomes, and provided opportunities where there once were none. I'm very pleased, Chief Justice, that you also referred to what the court did to advance the health outcomes or the health position of many of our people. When the court took the decision on HIV/AIDS, on the distribution of the medication, the court was contributing to the advancement of the rights that are enshrined in our Constitution. And for that reason, we are immensely grateful to have a judiciary that is independent, a judiciary that should know, Chief Justice, as I said, will never get a call from the President or from any minister about any case. I may call you about other things, like to discuss the independence, the full independence of the judiciary and the support you should get. All this progress has been anchored in our deep and abiding commitment to the protection and advancement of human rights as espoused in our Constitution. This Constitution, this birth certificate of our nation, will continue to be our lodestar as we work even harder. Our people expect no less, and our people deserve no less. And as we look ahead, as you said we should, Chief Justice, we need to determine what steps must be taken to give greater meaning to the Constitution and the Bill of Rights. We need to continue to contribute towards building a culture of human rights, not only in our country, but globally as well, which is our moral obligation as a country emerging from such a bitter past. Minister, you said gathered here are people who support human rights, but you also said, and I wondered whether that was so or not, that there are also enemies. And I'm yet to see any enemy of basic human rights. And if there is an enemy of basic human rights, I would ask them to raise their hands now, because I want the Chief Justice to deal with you. I wish this conference all the best in its deliberations. It is our expectation that it will come up with tangible resolutions that will further foster the respect for and the promotion of our hard-won human rights. And as I said, we still have a long journey to traverse. We are only 30 years old. Having struggled for freedom and human rights after 342 years, our journey is still a long one. But I'm glad that we have many fellow travelers who will make sure that indeed we do give respect to human rights for all our people. Thank you very much.
Mr. President, thank you. Thank you very much for the address to the nation and indeed for inspiring us as well into the future. I once was told that if we check around all of us in life, we are 5 people away from a most important person. I just want wherever you are seated, just make sure that you are just 5 people away from an important person. Me, I'm only 3 or 2 people away from so it means I've moved from the 5 closer. We have some few copies, 50, Mr. President. Due to budget, we could only print 50 special edition copies of the Constitution. If colleagues can just bring them to me, so by virtue of proximity, I'll be among the first who receive it. And indeed, we had thought, Mr. President, due to challenges of resources, we'll have a small symposium of 50 people. But we realized that this is such a big occasion that at least we can bring close to 1,000 people. If you can give them the copies, I can get one. Give the minister to do. So, yeah, Mr. Minister will give the President, the Chief Justice, the Chairperson of the NCOP, and the Speaker. I've already given myself one. I'll request that, Mr. President, yeah, you unveil it to the nation by, yes, and the Speaker. If we can all rise, Chief Justice, and then join the President and pose for the picture with the, oh, can we get another picture? Thank you very much, Mr. President. Ladies and gentlemen, I will request that we allow the President and his entourage to take leave. We may rise and just allow the President to leave to attend to urgent matters of the state. Okay. So, ladies and gentlemen, we'll ask the Chief Justice, the Chairperson of the National Council of Provinces, the Speaker of the National Assembly, the ministers and the judges here in our midst, and the ambassadors and the high commissioners to be given a space to move to the back for coffee and tea. And request that all of us, I'm told there are sufficient coffee and tea stations outside. This break will only be for 30 minutes. We have a very important panel that is going to start in strictly 30 minutes. That will be 20 to 12. So I request all of us to be back at 20 to 12 for the high-level panel discussion that will be facilitated by Professor Somadoda Fikin. So let's be strict with time and quickly get the coffee and come back. Thank you very much.
acknowledge people when you have so many eminent persons per square meter. So forgive me if I don't go through every one of them. I just ride on what has been presented as a protocol. We are in that next session, and we request those who are still coming in to settle down as fast as we can. And we're going to start, before I go to the panel, with a message of support from the UN High Commissioner for Human Rights, Ms. Volker Turk, and it's going to be through a bioscope. And those who are younger, it's going to be through a video. Because I know once I say bioscope, many will think that I'm speaking in tongues. If that video is ready, can we start playing it before I introduce my esteemed panelists? Thank you.
Your Excellency, the President of the Republic of South Africa, Minister of Justice, Excellencies, distinguished participants. It is an honor to address this national conference on the state of human rights that marks 30 years of democracy in South Africa. In April 1994, for the first time, people who had suffered appalling, lifelong discrimination under apartheid were able to make their own choices and participate fully and meaningfully in public life. Their struggle to achieve equality embodied both the universality of human rights and their meaning. Around the world, a generation of young people grew up in solidarity with your struggle. I among them, and I join you in celebrating this landmark. I also applaud this initiative to take stock of progress and the opportunities that lie ahead. South Africa's Human Rights Day, in 3 days' time, commemorates the 1960 Sharpeville massacre, when apartheid-era police killed and injured peaceful protesters demonstrating against the pass laws. The Sharpeville massacre encapsulates the horror of apartheid, which systematically denied the dignity and rights of so many millions of people. It captured a moment of sheer horror and the iniquity of apartheid and is commemorated annually across the globe as the International Day Against the Elimination of Racial Discrimination. I pay tribute to the people of this country for the determined mobilization that has brought so many advances in human rights and democratic governance. Let me mention some of the milestones. First, the Constitution of South Africa, which was signed into law in Sharpeville on International Human Rights Day, 10 December 1996, is one of the world's most progressive constitutional documents. The Constitution enshrines the rights of all people in the country to dignity, equality, and freedoms, with a wide range of human rights protections that mirror the Universal Declaration of Human Rights. Second, significant legal reforms have aligned many South African laws with international human rights standards. Legal barriers to equality have been removed, and efforts have been made to address historical injustices through affirmative action. Third, key institutions now play vital roles in protecting and promoting human rights. They include, of course, the Constitutional Court, which has been such an important human rights actor, and the South African Human Rights Commission, which is accredited with A status. The Truth and Reconciliation Commission enabled victims and perpetrators of human rights violations during apartheid to share their stories and seek reconciliation. Although many of these issues may remain a work in progress, it has contributed enormously to national healing, and it has inspired many other transitional justice processes around the world. Fourth, over 3 decades, successive democratic elections and a vibrant civic and political landscape have empowered South Africans to participate powerfully in public life, and I pay tribute to this country's tremendous diversity of civic activism. The freedom of South Africa's press provides the scrutiny that brings greater accountability. Respect for human rights is especially important during electoral periods. Fifth, the heroic action by many women during the struggle against apartheid, notably those who marched in 1956, helped to bring women's rights to the forefront of public discussion. Powerful feminist civic groups have flourished, and their work to dismantle the intersecting oppression of apartheid and traditional customs has contributed to better laws and greater public awareness. South Africa was also one of the first countries in the world to prohibit discrimination based on sexual orientation in its constitution and legalize same-sex marriage. I honor these tremendous achievements. South Africans have shown the world the resilience of the human spirit and the power of justice. South Africa is revered by many as an authority on human rights, and this has been demonstrated by its engagement on the international scene, including the country's membership of the Human Rights Council and standing invitation to the Council's special procedures, as well as its global advocacy on combating racism and promoting justice and accountability. Still, there are challenges, and one of the greatest is inequality. Although efforts have been made to realize social and economic rights, including access to healthcare, education, and social protections, significant disparities persist. Other critical human rights challenges include the persistence of very high levels of violence against women and girls, crime, social cohesion, particularly among communities that face economic challenges, integration of refugees and migrants, overcrowding in places of detention, and the growing threat of climate disasters. Action that is grounded in human rights principles is the most effective, most sustainable way to address these issues. And this anniversary that we are marking can be the call to action that gathers support to push forward with the work of creating a fully equal, fully inclusive society. My office and the United Nations family look forward to supporting you in this endeavor. South Africa has taught the world that human rights will surmount the worst challenges because, in the words of President Nelson Mandela, they can, and I quote, strike deep roots and blossom forever. Thank you.
Thank you very much. Let's put our hands together. Sometimes when a video is played, it has the convenience of no network disruption, but the other downside of it, you clap for a person who is not there, who might have recorded this few days ago. But please do convey you and colleagues our appreciation. The time we've been waiting for critical reflection on the journey that we've undertaken is here and is upon us. This is, Minister, the largest gathering that I can think of that is reflecting on the 30 years of democracy, how we have performed. And that in itself, congratulations to you and your department that all sectors of society have come and gathered here. We do know that as we come to assess the engine of this car, to check the oil in this engine that has been traveling for 30 years, we are here to service the car to see if it is fit to go for another 30 years. But one thing that is clear, one thing that is certain, is that we are not where we were in 1994. But we are also not where we intended to be. That is the most important moment of reflection. We are at the crossroads. If you are at the crossroads and your GPS still says trying to connect, we've brought these seasoned public intellectuals who have worked here in the country and across the world to connect us at that crossroads, because the GPS has been buffering trying to connect. Where do we go from here? Where are we? And where were we intended to be? As I prepare to call our first speaker, who needs no introduction, the beautiful thing, Minister, you did not even introduce the president. So I'll simply call the names for our presenters to come. You didn't say he went through this high school. He was expelled in this university. He was taken under this mission station and so forth. So I won't disappoint you and do that. I'll just call these seasoned veterans, public intellectuals who have operated in different spaces to come and reflect on various subjects. One of the presenters said during the break, Professor Fikeni, please, don't pigeonhole me to the topic. I said, no, without any hesitation. I said, I've come to release the pigeons. I will not be in the business of putting anybody in any pigeon as long as it is around human rights. So let me release my first pigeon to enlighten us. Dr. Matthew Posa, who is going to speak on good governance and accountability as tools to protect human rights. Ladies and gentlemen, distinguished audience, let's put our warm hands welcoming Dr. Matthew Posa.
Mr. President in absentia, I'm sure I'm allowed Minister of Justice to recognize him because he was here. Chief Justice Zondo, our Speaker of Parliament and NCOP, members of the Cabinet, representative of SADC and United Nations, and all other dignitaries. We didn't just have a Bill of Rights or a Constitution, Minister of Justice, as I recognize you. The President made reference to me. Let me start by telling this anecdote for those who are biologically disadvantaged. I was a commander in Mozambique of our army, Mkondo Sizwe. I was pulled from the front to Lusaka to join a team of negotiators, to join Comrade Nelson Mandela. I was briefed by Comrade Tambo Mbeki as follows: for the sake of those who are biologically disadvantaged, there were people in the death row. There were people in prison, not only Robben Island. The police had occupied our township and our villages. People were being chased in the street in all directions. And Comrade Thabo Mbeki says, Comrade Matthew, of course then I was called Freddie. He said, stop the hanging. As we land there, stop the hanging. Pull out the police and the army out of the townships. Get all prisoners released. Get all exiles back home. I'm summarizing a very difficult situation, Mr. Minister. There were many things I can note which happened before you were biologically advantaged. So we didn't just find a table to write the Constitution. We had to fight for the space to do so. The Bill of Rights, as it is enshrined in our Constitution, sets out a world-class framework for human rights. And human rights, in our situation, we set a goal for ourselves of a better life. We can boast about excellent policy documents, but with shockingly little to show in the area of execution. And other speakers have already alluded to that. There are two intrinsic issues which must first be interrogated: good governance, accountability. These two issues. I've been tasked to deal with them. And then the third factor becomes opposite, and that is an answer to the question, whether in the last 30 years we can boldly say that they have been applied without discrimination to protect human rights for all. Because the Constitution is unequivocal that while recognizing the injustices of the past, we, the people of South Africa, believe that South Africa belongs to all who live in it, black and white. So when we talk about protection of human rights, bear in mind that there is no hierarchy of either rights or entitlement to protection. There is no hierarchy. All the rights are rights. They're equal, and they must all be observed and protected. I can say without fear of contradiction that South Africa's constitution is one of the most progressive globally. However, the challenge which continues to plague me and most of us is whether we have allowed the aspirations and vision of the document to leave the paper on which it has been written. The paper is beautiful. What does our conduct look like? You know, you have heard people speak of the challenge of real rights and paper rights. I said paper rights. People often reflect on money as the root of all evil today. I want to say that bad governance is the root of all evil, the scares confronting our country. Bad governance. To be able to talk about an environment that protects human rights, we need clear dividing lines between the Cabinet, National Assembly, competent executive in both politics and administration, a dramatic cleansing of the cancer of corruption, as well as much improved institutions that need to hold those who deviate from the Constitution clear and guidelines accountable. I want to assure Chief Justice that we deplore those amongst us who rubbish the judiciary. We must take a public stand on that matter and say, we think it's improper. None of us should rubbish the judiciary. Let's go and debate in Parliament and rubbish one another. That's where it happens. But don't go and rubbish the judiciary. It is bad governance that has caused the demise of the nascent democracy. As year after year we see the decline of the democratic tenets with little or no consequence, and hold that idea of consequence management and accountability, because I will get back to it. In recent years, we have read headlines such as studies shows young South Africans have no faith in democracy and politicians. 2019 conversations. In a report from the Center for Social Development in Africa entitled Youth Transition in Communities, South Africa, youth reflected on government's failure to deliver basic services, each of which can be directly linked to one or more of the human rights enshrined in our Bill of Rights. Highlighted crime, unemployment, a stagnating economy, non-existent service delivery, and corrupt and self-interest political elite. I was saying in another meeting, Mr. Minister, maybe when the new parliamentarians take an oath, we must put a badge on their head. Thou shalt not steal. They must all have this in here. How do you explain when the Auditor General says 46 billion is unaccounted for? Seriously? Where did it go to? How many wheels or legs did it have? But it's gone. And it's gone in the hands of people who were put in trust. Thou shalt not steal in Parliament, Minister. Every one of the accusations underpinned by the dissatisfaction with the protection of human rights and directly contradicting the principles of good governance and accountability. Are the sentiments isolated? Are they reflective of a small minority of disgruntled youth? No. The youth lose confidence in government and politics and politicians because of what they see and perceive. Good governance and human rights are mutually reinforcing, and governance failures are directly correlated to human rights prejudice. Similarly, let me say that accountability in human rights is the ability to hold persons who violate human rights accountable for their actions. Did you hear me, head of SIU? He is here. We must hold them accountable. So we must go and arrest them after investigation. Which takes me to the point of integration. Good governance, accountability, and human rights. Each of you will have your own example, but I am citing just one, the right to food. Research tells us that South Africa is technically a food secure nation, yet almost 30 million people, 30 million, just under half the total population go to bed not knowing where their next meal will come from. I repeat, 30 million people sleep with hunger in this country. And you can't change that number unless you deal with the issue of food. And in the next breath, 2021, CSIR technical report on food losses and waste reports that over 10 million tons of food throughout the supply chain is lost or wasted annually. Why? Now, many rights in the Bill of Rights have a drawback provision of progressive realization and achievement based on reliable resources. Budget and resourcing are critical to the attainment of the socio-economic empowerment. And we all understand that the cow will give only what the cow can give. And that is very clear. However, when juxtaposed with the reported levels of corruption of public funds and the real or perceived failure to ensure that alleged wrongdoers are made to answer for their actions, people dealing with state failure to realize that human rights remain understandably disgruntled, to put it mildly. A well-functioning legal system is essential, competent of good governance. It ensures that ordinary people can seek remedies for human rights violations through fair and impartial judicial processes. However, when the system doesn't work, bad governance and poor accountability become the norm, and human rights have currency only on paper. You know, Master of Ceremonies, there are certain councillors, they are called Mr. 10%. When people in private sector go and tender legally, they go and visit them at night and said, please share me 10%. Seriously, 10% of public money, they're asking for it, but they're being paid as salary as councillors. That's what's happening. We need to stop these things. However, it is important to also record that when one studies governance failures, it is actually not the structure that collapsed, but the values and behaviors of those operating them. It is individuals. It is individuals. Laws are, in fact, only part of the governance solutions. Vital component lies in the personal standards of honesty, ethics, accountability, integrity, generally followed by members leading the enterprise, and the culture that is promoted. In the 2023 Elderman Trust Barometer, South Africa has the largest percentage point difference, 40%, between trust and in business, trust in government. 62 of the South African respondents said they trusted business, while only 22 said they trusted government. Those ratios need to change. What we need is more responsible leadership, which the Encyclopedia of Corporate Social Responsibility, Bergstein, Niner, and Avery describe as a leader who is deemed to properly and justly meet their roles and ethical obligations to their stakeholders and is willing to be held accountable for consequences of his actions and behaviors. Intrinsically, responsible leadership links with accountability. But responsible leadership has today become a matter of global concern, and justifiably so. In an earlier report on the leadership accountability gap, Malinaro findings are quite astounding. Of the 1,900 executives consulted, 71% agree leadership accountability is critical, but an often overlooked business issue. 80% of the respondents said that organizations often knew the unaccountable leaders, but did not have the courage to remove them from their positions. Why? Are they so powerful to have constituency, influence your votes, or your future, or your fate? Only 20% believe organizations have the courage to deal with mediocre leadership. Only 31% are satisfied with leadership accountability. I will not ask for public show of hands, but let's do a bit of silent introspection on how each of us would have responded were similar questions put to us. The fact is that governance and accountability are without a doubt the critical tools to protect, promote human rights. But the bell tolls for human rights when the governance and accountability become displaced or sneered at. What I'm saying is not rocket science, but it seems we have forgotten the spirit of the Bill of Rights and the purpose enshrined in the Constitution. South Africa has lost its way on good governance, and we need to restore that morality. We've lost our way on accountability. We need to restore the responsibility of being accountable. And now is the time to shine the light on corruption and all the negativity we experience in our government. At the end of the conference, if I can add one paragraph to the roadmap, Comrade Minister, one paragraph, it will be as follows. Commitment to re-establish good governance, 1. 2, the promise to assure accountability so that human rights and a shared commitment to the common good can shine upon again in the spirit of African humanism. And I will not take the Bible to Parliament, but they know as they grow up from Sunday school, thou shalt not steal.
Thank you very much. The problem with 10 commandments in our society is because they see them as 10 suggestions. That's where the problem is. They are commandments. Without any waste of time, moving to our next speaker, I'm always intrigued by this quotation by Amilcar Cabral. Always bear in mind that the people are not fighting for ideas, for things in anyone's head. They are fighting to win material benefits, to live better and in peace, to see their lives go forward, to guarantee the future for their children. As we move to the next presenter, a person who needs no introduction, a person who was there in the crafting of the new administration. Here we are bringing the midwives of this constitution to come and see how the work has gone. But our crisis, as some of the speakers have said, is the gender agenda and the gender inequality and all kinds of challenges facing women. And Umamu Geraldine Faiza Molegeti is going to speak to that topic and go beyond, because it is one of the burning issues of our time that is simply refusing to go away. Let's put our warm hands together.
Thank you, and good afternoon, everyone. I'd like to acknowledge everyone present, the Minister of Justice and the Executive, the Chair of the Council of Provinces and Parliament, and all the legislatures. And let me say the judiciary. I don't see the Chief Justice here, so the judiciary as a whole. I wanted to separate the three arms of the state first, and then continue and just acknowledge everyone present here today. And yes, it is a magnificent, magnificent gathering, because it brings together, I believe, a group of people from all sectors of society, and above all, it's intergenerational. So it makes this 30 years potentially a little bit emotional, but emotional because of the realities around our Constitution and what it stands for. So our MC has started with quoting Amilcar Cabral, and I won't go there, but I'd also want to use a couple of quotes. But before I do that, I'm not quite sure, where's the DG of Justice? Doc, you know, I remembered this morning that on the 4th of February, some years ago, at 10 a.m. New York time, I had an engagement with you, and now a DDG in your department. And we were discussing matters of sustainable development goals and event and process around it. I'm not going to bore the audience with the details. Safe to say that I learned thereafter that it was Doc's birthday that day. And he felt that he got a drubbing through that discussion and was quite upset by that. So, Doc, I want to say, I think we even today. I think we even. But as we are even, let me just state, and I'm going to come to further anecdotes as I continue, but let me quote Gramsci, if you will allow me, Antonio Gramsci, when he said, "I don't think we have any alternative other than remaining optimistic. Optimism is an absolute necessity, even if it is only optimism of the will and pessimism of the intellect," close quotes. And the reason I raise this today is because we are going to reflect on 3 decades of our democracy, and we're going to reflect on our Constitution and draw on it as we do so. And this will enable us to raise a number of truths, but we do so because we have optimism of will and because we have this collection of people here and the millions out there who are unable to join us in person, but for whom we must ensure that there's optimism of will. So as I speak today, the rights about which we are making an assessment on progress or otherwise are a constituent part of the supreme legal framework of the land as embodied in the Constitution. Chapter 2 of the Constitution, and this was mentioned a number of times this morning, that is the Bill of Rights, spells out these rights, which are guaranteed to all persons in the Republic, irrespective of race, class, gender, or any other considerations. So given the flagrant denial of rights owing to the legacy of colonialism and apartheid, it fell on the new democratic government to put in place legislative, policy, and programmatic interventions in dismantling this discriminatory legacy. The task at hand here is to take a bird's eye view on how such legislative policy and programmatic interventions have fared over the 30-year period, ensuring that women also access these rights that have been guaranteed to all under Chapter 2 of the Constitution. The assessment will by no means be exhaustive, given time limitations, but also the paucity of gender disaggregation across various bodies of work on human rights evaluation research. In that, I wish to argue today there has not been much systematic evaluation on the various provisions in the Bill of Rights purely focused on women engaging the desired level of impact on women. This does not negate the fact that there's been considerable improvement in the lives of women as a result, and And sorry, I must just find my space. You see, the phone doesn't keep still. And that. So this does not need to negate the fact that there's been considerable improvement in the lives of women as a result of the enabling legislative, policy, and programmatic interventions as at the level of the state, as will be shown momentarily. So while challenges abound, and far too many women are still finding themselves on the margins, it would be dishonest to eschew that the many gains women have made since 1994 as a result of the legislative, policy, and programmatic interventions put in place by the state. It is within this context that the ensuing critique should be considered. Secondly, it would also be important to situate my critique in its proper socio-historical context, thus acknowledging where we come from as a nation. Perhaps the best way to illustrate the point about whence we come is to tell a story of women's struggle within the law profession, a story which does not only speak to matters of the law, but also the issue of the denial of fundamental rights of women. So many years ago, a retired constitutional judge wrote an opinion piece for the Sunday Times, Sunday newspapers titled, and I quote, "The law is a arse." And I'm saying arse, not ass. Many years later, that same story was confirmed by a prominent lawyer and scholar, Tembeka Nukatobi, in his book. Advocate Nukatobi confirms the story as previously told by Judge Kate O'Regan, and this is the story of one Madeleine Unahuki, a white woman from the Cape who had applied for admission to the Cape Incorporated Law Society as an articled clerk to qualify as an attorney. The secretary of the Cape Incorporated Law Society declined to register the articles. Ms. Wuki then filed an application with the courts to seek relief against what she thought was an unjustified and arbitrary decision by the Cape Incorporated Law Society. The lower court sided with her and ordered the Cape Incorporated Law Society to register her. The Law Society launched an appeal against that judgment with the Superior Court. At the heart of the legal argument by the Cape Incorporated Law Society was the reference persons in the Cape Charter of Justice. The applicant argued that the reference persons in the statute did not include women. In other words, so argued the Cape Incorporated Law Society, since women were not persons, people, or human beings, and the writers of the Charter would not have had women in mind, but rather white males. The Superior Court must set aside the earlier judgment and the resultant order against them by the lower court. Now, as astounding and chilling as it may be today, the Cape Supreme Court, led by Chief Justice Rose Innes, set aside the earlier judgment and refused Ms. Woolley, and I may be mispronouncing her name, her application for registration of her articles of clerkship, and thereby ruling that the reference person in the applicable statute did not include women. And in the early stages of the 20th century, women were not persons, women were not people, women were not human beings. And thus, this formed the foundational basis for the denial of rights across many strands of national life. For example, women were barred from many professions deemed an exclusive domain of men. Women could not own property. Education was deemed a great privilege to women. Women had no social, political, and economic rights. But at the very heart of this flagrant denial of rights was the deeply held prejudices against women as to go as far as to say they are not human beings, they are not people. Of course, that picture changed with the passing of the Women Legal Practitioners Bill in 1923. In the latter years, the court saw the admission of the first black woman, Desiree Finger, as the first black African woman to be admitted as an attorney in 1967. And so, how have we fared since the dawn of democracy in 1994? And now I wish to sample a few provisions in the Constitution in terms of Chapter 2 of the Bill of Rights and where we are in relation to women. As I understand, all guarantees in the Bill of Rights are relevant to women, but some have more immediate and direct bearing on their day-to-day lives than others. Therefore, it would be those same rights that have a direct bearing on women's day-to-day lives that I'd like to highlight as to trigger further thought and stimulate debate, as I shall below. So also, I wanted to say, Dr. Posa, that as you put the sticker on "Don't Steal," there should also be a sticker that says, "Don't be a misogynist. Don't abuse women and even other men." And that's when you take that oath, and whether you're in Parliament or not. It also says that, truth is hard, and we need to be consistent with truth. And maybe that sticker must have all that. So it must be a big sticker, and it's a sticker for everyone. And let it be known that those who think that they can hide behind positions or clad in some offices across, whether it's the executive, judiciary, the legislature, or interfaith structures or elsewhere, you are known for what you do. And your peers may cover for you, but you can never hide. Because lies have short legs. So Section 10 of the Bill of Rights, the right to human dignity, and following the story I've just related, and the rather peculiar interpretation of the relevant provisions in the statute, that the reference of persons does not include women, I thought perhaps this should be our point of departure. The issue, and I've touched on one of them earlier, like racism, sexism, patriarchy, and misogyny. Because these are ensuring social constructs and have staying power, because they are ideological, cultural, and at times religious machinations that buttress them. At the heart of it all is the strongly held beliefs throughout society, at times with an inadvertent acquiescence of women, that there is something innately superior about men, and with the reverse being true about women. So we're ready to accept mediocre men in senior positions, but we don't like mediocre women there. And we just, when it's equalized, we sort of put our hands up. And I think the time has come for us to say we want excellence from everyone, not just from women. We want the same from men, and we want to see it in practice. And it's on account of this ideological orientation that women find themselves in the precarious position simply because they are not deemed human enough. And let it be known, the only qualification to assert one's right to human dignity is just simply being human. Thus, the acts of subtle discrimination, sexual assault, rape, and even rape cases that get withdrawn time and again, depending on the seniority of the persons engaged, silencing would all occur if, in general, society continues to be indifferent to women's presence and their being. Let me go on to sections 11 and 12. The right to life and the right to freedom and security of person. It's quite telling that while women have made many inroads in many spheres of national life since the dawn of democracy, the scourge of gender-based violence and femicide has surged upwards and unabated, and thus very directly infringing on the women's right to freedom and security of person, and even most unfortunately, on women's right to life, which is considered an inalienable right, together with the right to equality, human dignity, and privacy. This denial of the right to life is most exemplified in the scourge of GBV and femicide, with some chilling data since the new constitutional democratic dispensation. And the rise of GBV and femicide happens on the backdrop of a progressive constitutional, legislative, policy, and programmatic interventions. But we're not doing enough on the implementation. And women are remaining silent and told to remain silent, as we saw with a recent case of a woman taking the matter of her partner having raped their baby to court, and the family members beating her up after the sentence because he was a breadwinner. There's something that must change in society, but it's the broader issue that is linked to the Cabral quote that we need to come back to. And the public sector must ensure that those of us in positions of responsibility, and every one of the 1,100,000 public servants must do their work and not point to others, because at the end of the day, the broader society is dependent on you. The vulnerable, the women are dependent on you. And we shall not remain silent, and we'll call people out. And I can go on, and I know I've got 2 minutes, MC. So the last point that I probably want to make could be on the issue of the right to education. But I think that's going to come up. There's a very capable panel coming up. and I was going to again refer to the court case earlier, but I'll hold back on that one, as I will on Section 10 to the right to human, as I will on other parts of the Bill of Rights. But it shows that this discussion that we're having is overdue. Section 9 on the right to equality, and I think I want to conclude on this. We must pay tribute to the founding parents of our democracy. There were no midwives here only. It was men and women, because we were there as women and men, and that's where we proudly say our Constitution does not have founding fathers. We don't bow and scrape to them. We are founding parents, you know, and I think it's necessary to state that. So yes, we know where we stand globally with respect to that. But one of the relatively effective pieces of the legislation in advancing equality, especially at the workplace, is the Employment Equity Act of 1998, which designated certain categories for preferential treatment as a positive measure to achieve equality. The latest Employment Equity Report of 2023 shows that the country has almost phased out the previous practice of unequal pay for equal value of work because of gender. In the report, of the 380 total referrals to the CCMA that have involved pay discrimination, only 3 were said to have a gender dynamic, with a majority of the referrals, about 91%, being said to be arbitrarily determined. And so, I can go on, and I could today have spoken about my experience of governance globally. I could have spoken further about characteristics that make democracy work. I could have reflected on intensive investment in participatory democracy. And yes, I will say one word, a few words on this. Democracy envisaged in the South African Constitution is participatory. Not only about accountability and fairness for the electorate, but to ensure better outcomes when people are engaged and listened to in the formulation of law. And we should never forget that. We get better outcomes where people are more knowledgeable about the law. And that's why to the Department of Justice, I want to also say the legal literacy of our people need to calibrate with the system, legislation, and policies. It's absolutely important. And I conclude on one note, and I want to be anecdotal. And I'm sure there's many people in the room. So when the Minister of Justice said he had a biological disability, and we don't count that as a disability, Minister, there's a young man in this room, and I want him to stand, Salomzi Moleketi. Salomzi Moleketi was the baby who was at CODESA when I was a member of the management committee at CODESA, and when we negotiated that constitution. And that was because we were quite clear as the progressive women and men participating that what we wanted in the Constitution and the Bill of Rights would be in the room. So we were not going to leave the babies outside, and that baby was breastfeeding at the time. And it's so many years later. And I think the point I'm making through that example and that anecdote is that this Constitution is not something that should be seen as simply something on the shelf. This is about the lives of our people. This is what must ensure that there's food on the table and that there is the creation of jobs. And when Amilcar Cabral spoke at the time he did, he also, through his words, wanted to ensure that people are empowered. And we fought for this freedom. And we will defend this freedom and this democracy because it must change the lives of our people. And all of us must make our contribution. There's no room for spectators. This is not a sport. This is life. This is about equality. This is about dignity. This is about justice. This is about the South African people and our responsibility to the peoples of our continent and the people of the world. Thank you very much.
Thank you very much. Ending on that very important note, democracy is too important a project to be a spectator sport. Democracy works because you take ownership. It's not for the department, it's not for another government, department, or another person, or the judiciary. It's when all the wheels are oiled to work. The other point raised, which I think as we move on with this conference is very important, the importance of hope in face of temptation of despair. We have nothing but hope that will spur us to action, because despair will make us freeze into nothing. As I prepare to call the next speaker, on that notion of hope, it was in August 1963 that Martin Luther King Jr. said, even though we may face the difficulties of today and tomorrow, I still have a dream. What is our dream? To make this Constitution real. On the issue of women, there is one country called Afghanistan and an organization that came in and just sent women professionals home. Send children who happen to be girls home, not to go to school. And it's there in the media. But I want to say the reason we have these challenges we have in our country, there is a Taliban in each one of us that we're refusing to let go. But it doesn't come as a regime. It comes when we fail to take our responsibility as men. The next subject, by a well-known clinical psychologist, a global leader on issues of human rights, is on eliminating racial discrimination and other intolerances. You'll remember when W.E.B. Du Bois, at the beginning of the 20th century, he said the problem of the 20th century will be the problem of color line. Little did we know in the 21st century we'll be saying Black Lives Matter. Little did we know that we would have two wars happening at the same time, and we see the color line in terms of how we sympathize and relate to those wars. Racism, it's like a disease or a flu, it mutates. You develop this antibiotic, it mutates. Like Retex, it used to kill rats, now they look for it for breakfast. Let's call Dr. Zonke Majodina to come and present on the issue of racial discrimination and other intolerances. Let's put our hands together. Thank you.
Program Director, and I'll pick up on your last observation, or the quote by W.E.B. Du Bois, who said, the problem of the 20th century, we're now in the 21st century, is the problem of color. I mean, I'm paraphrasing him. And I'll get back to that because my topic. Okay. Mr. MC, let me first acknowledge this invitation and how grateful I am to be part of this august assembly. We have been talking racism long before the new democratic South Africa, but we still haven't cracked the nut. Racism is still with us. Let me start by saying that, or rather, let me acknowledge all the people in this room, including Chief Justice Zondo, who I thought will still be here, but similarly, heads of the three arms of government, let me acknowledge them if they are here, members of the diplomatic community, members of the human rights international community, and let me say all protocol observed, because I do not have much time. I've been given 10 minutes, and I hope not to overstretch that 10 minutes. In South Africa today, experiences of all of us, whether black, white, Indian, and so-called colored, we are always forced into racial thinking. I belong to this and that race, I belong to that race. And these racial identities then become part of social systems, such as in the educational, labor sectors, where we still revert back to those racial divisions that we're conditioned to. Racial thinking goes with a tendency to devalue the other, a staple of the apartheid regime. Currently, the debate around race shows different understandings by different groups. Deep-rooted prejudices of white South Africans and the many recollections of injuries suffered by black people lie at the heart of these different understandings. Similarly, with xenophobia, black South Africans blame South Africans blame other Africans for bringing high unemployment and crime in the township. This is an example of the different understandings, because a South African will not think along those lines, mostly, but some do. So what has helped in all this controversy around definitions and understandings is that after 1994, we rejoined the community, the international community of nations, and learned from standards set at the level of human rights bodies. In 1963, the international community declared racial discrimination to be a violation of human rights, especially apartheid. The International Convention on the Elimination of Racial Discrimination was adopted not long after the declaration that racial discrimination is a crime, a violation, and in fact, South Africa, a crime, in the case of South Africa, apartheid being a crime against humanity. I won't take long in definitions and all that because we don't have much time and I've got to keep to the 10 minutes I've been given, so I'll try to be fast. Since 1994, South Africa's Constitution and Bill of Rights set up an impressive legal framework that translates the principles of non-discrimination from Section 9 of our Constitution into binding norms and rules. These include the provision of civil remedies for victims of racial discrimination, use of languages other than English and Afrikaans, which we are now free to use in Parliament and in many other public spaces. Nonetheless, reports of racial violence, racial discrimination from the times of apartheid have continued to be of concern, particularly the economic, social, and cultural disparities we see today, undermining the realization of a truly non-racial society. In light of this, President Mbeki in 2000 called for a national conference on racism and asked the South African Human Rights Commission to convene it. The conference did take place and came out with a national action plan against racism. Remember, this was 2000, and a year later, the World Conference Against Racism was going to be held here today. So our national action plan became the template for many other countries to draw their national action plans, from Finland up north to New Zealand down south. So surprisingly, many countries did in fact take to the recommendations of WACA, the World Council of, the World Conference Against Racism. Let me come up here. In the case of South Africa, a very important piece of legislation was passed in 2003, and that is the Promotion of Equality, Prevention of Unfair Discrimination Act. We call it PEPUDA, but for purposes of this conference, I'm going to talk about, I'm just going to refer to the Equality Act for short in order not to waste the very limited time I have. As I said, many other countries have come up with their national action plans, and these plans are being reviewed all the time by international human rights bodies. So the state, the South African state, as a member of the international community now, sanctions discrimination and is enjoined to take proactive measures to transform society to achieve full equality. The Equality Act provides for the setting up of equality courts, which are a less adversarial court system empowered to order remedies outside the normal range of civil remedies in other courts. Let me give you the example of one of the first cases in the early 90s, mid-90s, by the chairperson of the South African Human Rights Commission at the time, who is now a judge. Judge Colapin went to an equality court, which has been provided for in the Equality Act. He went to complain that when a hair salon in Pretoria saw him entering, these are the early days after 94, the owner of the barber shop said, "We don't cut ethnic hair." So this is what made Judge Colapin go to the Equality Court. Indeed, his case was heard, and the presiding officer ordered that the owner should apologize unconditionally to Mr. Colapin, and the barbershop staff were then trained. These are some of the orders. Barbershop staff to be trained, and these are some of the creative remedies that magistrates come up with in equality courts. The other order was that the barbershop should pay 500 rand every month to a NGO of Mr. Colapin's, I hope he's here, of his choice. But that just goes to show that equality courts have a very huge role to play in advancing our non-discrimination and our rights to equality. But these equality courts have faced a lot of difficulties. For example, lack of access to these courts, which sometimes are not even advertised where people could locate them. And when you do go to these courts, it's as if equality is something that most magistrates, let me not say magistrates, most of us are not comfortable with. So in courts such as in Joburg, which is one of the biggest courts, there's no signage. You go there, you fumble around, and nobody knows where an equality court is located. Not only that, the training of clerks, equality court clerks, leaves very much to be desired. For a huge piece of legislation like the Equality Act, clerks are not properly trained. They are given a once-off 3-day training, so much so that a lot of magistrates don't take to their tasks as it should be. I remember going to White River and meeting a magistrate there, asking him whether he's been trained. And he said, no, why should I be trained? These human rights issues of equality don't concern me. So I said, what, for example, do you do if there's a woman who claims to have been, whose rights have been violated on the grounds of gender and race? Because remember, these rights intersect, but I won't have time unless maybe during question time. He said, I just send these women to a maintenance court. This has nothing to do with the equality complaint. So that just goes to show the dismissive attitude of some of our legal officers, and especially from the past. This gentleman was from pre-94. So to him, equality did not mean anything. So apart from I was just elaborating on some of the. Yeah, I've just read through some of the problems that these equality courts that were set up with very high hopes that they were going to be transformational in the lives of Black South Africans especially, and women in particular. Let me just talk about how women, I've just been doing a study on how women access and utilize equality courts. There's a lot of legal illiteracy among us. I include myself because I was very much afraid of courts for all kinds of reasons. And women over the last, let's say 20 years, have been very loath to approach equality courts. I think, let's say in 20 years' time, I can count not more than hundreds of women who have approached these courts. So this leads then to underutilization of quality courts and the fact that they are inconsistent. Some parts of the country are, especially in the urban areas, there are lots and lots of cases going to equality courts. But women everywhere, whether urban or rural, find it difficult. So one of the recommendations will be to do with that. But we thought that equality courts will be a key mechanism for advancing equality in South Africa. But because they are relatively new compared to our old established legal systems, their full potential is not understood at the moment. They have not really functioned as well as they should have, which means that we need to strengthen our oversight activities by both government and civil society organizations. Before I step down, let me just make a couple of recommendations. One, in view of the fact that we're talking about racial discrimination, I think we have passed a lot of laws. We've created institutions such as Chapter 9 bodies, and but we have not reviewed their impact and effectiveness. We have set all this up, and even the research I'm doing is to do with how much impact these courts have had. But it's not just a little private entity at VETS that should look at these courts, but we need to have an oversight body. By the way, there is the Equality Review Committee that was set up to do just that, but it has not met its obligations. That committee, which is supposed to be part of the Chapter 9 establishment and some government entities, has not functioned in the last 15 years, I think. And so, again, in reviewing our policies and their effectiveness, we need to actually undertake a formal government-led, civil society-led initiative to see whether what we have pronounced on and set up has worked. The other recommendation I want to make is setting up of a human rights monitoring project to facilitate compliance with our treaty body obligations. I did not go far in my account of how treaty bodies were established and what their role is, again, because I didn't want to be long-winded, or long-winded, maybe. So, after these recommendations, I just have one last word. When we talk about racism, racial discrimination in South Africa, we refer mainly to previously disadvantaged groups. I'm not comfortable with this term because talking about previously disadvantaged groups ignores the ways in which the effects of institutionalized discrimination of the past manifests today. In fact, the majority of blacks are disadvantaged now, today, and not only in the past. So maybe we could devote a little time to say, does it work to talk about previously disadvantaged bodies? Formal legal apartheid laws have been repealed, but we're still struggling with social, economic, and cultural apartheid that has remained largely unchanged. And so a question we need to ask ourselves is how many poor, landless, homeless blacks enjoy the constitutional protections we have, such as the right not to be discriminated against, the right to be treated equally, and the right to access justice when this right to equality is violated. Let me tell you the story, one last bite at the sherry, just to illustrate how poor, landless, homeless blacks, what their fate is, their plight is, even despite all this legislation and beautiful institutions. A woman from Mpumalanga, I'll call her Anna, hears about the existence of these courts, and she has been abused over and over by her employer in Mpumalanga on a farm. So she wakes up one morning, the only morning she was free, very early, at the crack of dawn, goes to Barberton to look for an equality court, because at the time of raising awareness, people heard, but had very little information about how to access these courts, how to get legal assistance from clerks of court, because remember, you cannot launch a complaint of racism, and the court will not hear that case unless there's a designated equality court clerk, and of course, the presiding officer also having to be trained as well. But we have very, very few of such trained officials. There is, how can I put it? They're very few and far, to the extent that when a court in general decides that there are not enough quality cases brought, they close that court, and you find that after training the magistrates, training the clerks, they don't have any work to do on equality matters, but because they are part of the legal system, they have other duties to fulfill. So they are now taken away to some less or even more important, because magistrates think that these equality courts are a nuisance. So hence my question. Here is a landless, poor, homeless black woman. How does she enjoy the constitutional protections that you and I can access, and the right not to be discriminated against? She went home empty-handed. She was not able to locate a court in that magistrate's court in Barberton, and had to go back at night, having waited and roamed around looking for directions and not being helped. I've also had that experience here in Johannesburg, where you go through a maze of corridors and nobody knows where the Equality Court is. So I leave you then with that question. How many of us as blacks enjoy the constitutional protections that have been laid out from Section 9 all the way down to equality courts? Thank you very much. I hope I haven't taken too much time.
Thank you very much for that presentation, which emphasized that at times we do have these institutions, but they are not well resourced, they are not readily accessible, and sometimes they are not there in the communities. And at times you're tempted to do that proverbial saying, how do we make these institutions roll down to the communities where they are supposed to be? The key theme that comes through all the three presenters is the issue of inequality. With these levels of inequality, can we access and make meaningful use of all these rights? I guess it's also the balancing of your first, second, and third generation human rights. But now we come to an end of this session, and we really appreciate, Minister, and your department that you realize how sensitive the next topic is, the issue of land, that you can't talk about land on an empty stomach. It could cause serious indigestion. Hence, we will be breaking for lunch, but we will have a member of the department, maybe DG or a designated person, to tell us where we go, just to fortify ourselves for this next topic. Thank you. Let's put our hands together for this wonderful audience. I am told that whilst the kitchen is finalizing, we will have people who will rove just for 10 minutes with the microphones to get a few questions for our panelists. They can't get out of the stage so easily. But the issue still stands that we can't talk about land without first eating. It is that sensitive. Otherwise, it will cause the gastric juices and other things to that churn on itself. Can I see a show of hand? I see a hand right there. If we can start with you, right there behind the cameras. Your hand is up, and I'm hoping that, yes, you identify yourself, and also try to be brief to allow for many speakers. There should be no keynote question. We do no keynote addresses. Just be brief, then you know the human rights of others who want to ask questions have also been respected. Over to you, sir.
Thank you very much, Mr. Program Director, Professor Figeni. I am Mashalera Pata. I come from the University of Limpopo. In the best interest of time, all protocol observed. During the presentations of the speakers, there are a few things that I've noted, but then I'll speak to one, which is around the question of the right to life. And I want to talk to fellow South Africans. 30 years down the line, we had S versus Magwanyani, well understood. That's history. Today we live with critical problems, critical challenges. As we sit here, a woman, a child is being killed somewhere. what are we doing about this question of premeditated murder? We can't continue talking about the right to life at the expense of law-abiding South Africans. We've got to do something about this. I'm happy because Honorable Fraser Mlegedi says it. She's saying something got to be done. It can't be that 30 years into our democracy, we are still not free. I'm not sure if I can be able to walk freely out of this wall.
So the issue of personal security, super.
Definitely. So I would want to see the reaction of the presenters on this particular question. We can't be stuck with S versus Magwanyani. The law must be developed, even if it means premeditated murder must be a subject of hanging or death penalty, be it. Security must be prioritized.
Thank you. That point is made. And those who are coming, I see a hand there. And you are also exempted from any protocols being observed. I've done it on your behalf, just to save time. You just go straight for it and you make it crisp.
Positive Vibration Energies. My name is Nicolene Trom from West Village. The first speaker had just made a good point of the vital to life philosophy. 30 years in democracy, we still do not have a philosophy that informs our thoughts, our speech, and our actions. Hence, we are receiving such high crime rate in the country and such lawlessness because we had not yet gone back to basics as to restoring and resuscitating Ubuntu. The government has made it a slogan, but if we can go back to basics and ensure that it is our currency, it is our way of living, because we've got people in parliament that are moving away from Ubuntu. Hence, we are having good laws only in pen and paper, but implementation of those laws is non-existing, and executing those laws, it doesn't matter, because there's also no repercussions for those that are in positions using power to subdue the people rather than to liberate the people. I thank you.
Thank you very much. And our contributors have been amazing by being very short and concise. And the next one is not going to fail in that. I can pledge on your behalf.
Good day. Kgotatso Moloto, the founder and president of Voice in Action. I'll be very short. I wanted to say to the President of the Republic of South Africa, from one president to another, and I do believe that one day I might sit in that seat. We do not want to see the next 30 years not having been empowered as young people. 30 years from now, we want to come back and say, I was sitting in this conference and the president gave me a few minutes to make sure that I was heard, but he also gave me the opportunity to ensure that we implement at least 3 things. Because we can talk. You know, I was talking to the team here of young people and we're saying, the president, the ministers, and other presenters have spoken. We will become the implementers, but give us that space to implement. We do not want to wait to see another 30 years to talk about the things that have not been done. Let's talk about what we are going to be doing. Let's talk about how young people are going to be empowered and given the opportunity to actually make this difference. I believe that together we can strive to see a serious change in the country. As Voice in Action, we've got 3 objectives. 1, to create 1 million sustainable employment opportunities. And we are challenging government to say, let's work together. We have these ideas. This will not only ensure that the rights of every South African is achieved or ensured or protected, but it will ensure that the future is protected as well. Let's work together to achieve these objectives. The final question is this. Will we be given a space as young people to implement what has been discussed? I thank you.
Thank you very much. Again, equally short which means the pressure on those who are standing to ask questions is more because everyone has been to the point. The next question.
My name is Zwelindaba, the chairperson of Sisonke People's Forum. I'm just greeting everyone, protocol observed. My first question will be directed to justice in general. Looking to chapter section 198, that has been failed because we as a nation, we are not living in that harmony. Why are they not touching it, but going easily touching these Bill of Rights? Because now we as the nation living in fear. Then I'm moving to the issue of GBV. GBV is a two-way street. It's a violence that goes to the woman. It's a violence that goes to the child. And again, it's a violence that goes to a man. Because now we need to find out where all this started, that we need to have a mechanism on fighting it. That mechanism, maybe we can say, love me for me, not love me to change me. Then coming to the issue of xenophobia. That touches my heart because today there is this section 13, if I'm not mistaken, of Immigration Act of 2002, where there is a list of jobs that were reserved for South Africa. But if South Africans are talking, this famous word, a gun without bullets, xenophobia, only goes to South Africans. What about the rights of our kids that are sleeping under the bridge, eating drugs? Nobody talks about those. What are you saying, guys? We are in 30 years, but on those 30 years, we are not enjoying these freedoms, these rights. You are just having rights on paper. Practically, we are having none. We are South Africans, we are living without jobs. We are living without food. We are fighting the battle that no one, even in politics, even in justice, listening to us. I thank you.
Thank you very much. The other beautiful thing here, as I point the hands, I think I've even seen my brother Miles here, is that we are in a season which is 2 months away from that important appointment with destiny. And I really like that no one of you has gotten the temptation to go to their manifesto. They just know that we're all in this house just to look for solutions. Let's see, who is assisting me with the sequencing, because there are 2 lines, one at the back, one in front. And we are going to take now the last 3. Remember, we have 3 days when we'll come back to these questions. And I plead, would you mind if I start with the young folks there at the back, because they've been standing for some time, especially in this generational mix, because we will not be around when they face some of the things we do now. So please, if the mic is taken there, and we will just take 2 of you and then 1 here, and then we close it for now. We have...
Program Director, sorry. Upega one side, ngapha bakhona nangapha siyaphakamisa silosimile. Sizwa sengathi niyavala manje kodwa sifuna ukukhuluma. Program Director, please, bheka yonke indawo.
Thank you very much. What is happening is that these lights are also helping to make some people invisible. We are most visible to you. Now I can see that there were people here as well. If we just take maybe 2 there, very short, and 2 here, very short, and I will meet with those I will not have pointed out. I will ask for forgiveness during lunch. Just 2 there at the back. Or else let's start here if the mic is ready, because it looks like the mic is
yes,
not ready. Right.
Micro is ready. Sanmonani, zinkokheli ngaphambili ngokulandelana kwehlalo zeni okhulumayo undabezitha umlungwana chairperson weContralesa ekuruleni bahlonipheki kanye nomkhumbi wonke osendlini thina sinasi isikhalazo singamakhosi amakhosi eSouth Africa abekelwe eceleni amakhosi eSouth Africa iyona nsila yabantu base South Africa uma kuwenziwa inhlelo njengoba nikhuluma nje namhlanje ngokuhlukunyezwa komama nabantwana thina sibona lento 24 hours kodwa nisinvolve ekuthenini sikwazi ukuthi sibonise inkinga ezenza ukuthi abantu bahlukumezeke nishiye eceleni bayohlala behlukumezeka kabantu bekwenzeka izinto ezingafanele zenzeke eSouth Africa ngoba nathi manifika nathi nina nisafuna ukuthi izwe liliwe physical ngemkhonto seniyolilwa ngeballpen anizange sabuya nizoreporta lana thatha khona umkhonto ngiyabonga amen.
Thank you very much, Ndabezitha. And I want, is the mic there now?
Yes.
Just one question there, and then we will come to one question, and then we close with this one. And we meet with those who are left outside to tell them how they are going to be given the first chance next time.
Good day. My name is Ntsaki Kumalo. I'm 23 years old. I'm standing here representing Katwaga's Parliament. Thank you for this opportunity to gather with such persons. My concern today is about basic human rights like the right to life, liberty, freedom of slavery and torture, freedom of opinion and expression. Lastly, the right to work and education. Basically, my concern for today is the right to expression as one of basic human rights. Normally in courts, the litigants are told not to discuss the case up until it has reached the final stages or judgment. As the court official will say, it's a sub judice. So my question for today is that not a violation of a litigant freedom of expression? Thank you.
Thank you very much. And the young man, and then we will close with the cardinal here.
Thank you so much, Program Director. All protocol observed. Oh, thank you so much. Mine is just short and simple. 2 weeks back, we celebrated 75 years of Universal Declaration of Human Rights, of which also we are speaking about the 30 years of freedom. But I want to find out that from the panelists, how best can we actually integrate the social structures with the government structures so that we build the resilient systems, especially in terms of human rights, because I'm coming from the civil society as well. And when we do our civil society work, sometimes down the line, we find ourselves encountering challenges with the government-appointed authorities because we don't have that established strong mandate of working hand in hand. And if we, I also do believe that if we start working in solidarity, then we can actually lessen the work that burdens the appointed authorities of the government. So I just want us to get to that point of saying, how best do we come together? We bring what we have, and also the systems bring what it has, and then we just find a way forward. That's all from my end. Thank you so much.
Thank you very much. The last one, and everyone has not gone beyond 2 minutes or even 1.5. The last one won't disappoint. Over to you, Khan.
Thank you. Greetings to all honorable, distinguished excellencies in the House and the leaders of various sectors. I am Cardinal Shole, the leader of Faith Base at the African Peer Review and the leader of civil society at Netlek Community Constituency. Beloved, I'm here as a leader of South African Union Council of Independent Church. Chair, I only responding from 2 issues from the President of, from Chief Justice and also from Dr. Posa. I've got a very concern of the violence that is taking place in KZN previously. And now the new party, political party, is rising up. There are some threatening that there will be violence, there will not be elections. And the other thing is that the former president, he has finished the term of 2 terms. Where does the Constitution can be approached to nullify this threatening of violence on the television by the new political party and by the former president, whose plan is to go back to parliament? And because according to section 1 of the Constitution, we are a sovereign state supremacy of the law that modifies the party of democracy. I've written down when the Chief Justice was giving us educational on the Constitution, and he says on the section 2.
I'm told that the kitchen will be closing soon. And they are confusing me, I don't know why. So you just want to ask a question, but
the question is,
I think we got the gist.
The message is clear. Is there any way that we can protect the Constitution of South Africa, the fundamental rights of the Constitution?
Thank you, we got the question.
Thank you.
Thank you, thank you. Can we do this? Can we do this? When we come back and we're going to have questions, we will have to deal with how we deal with some of the issues, so that the rules of engagement, when we have this size of audience and diversity, can end up going in every direction except where we wanted it to be. So let's bear with the fact that one of the panelists is leaving. Can we get the response from the panelists? And I'll meet with those who still have to ask questions, because we have 3 days. Thank you.
Colleagues, I want to try and respond to a few of the questions. We understand that we are in a silly season of elections, and sometimes the temptation to put one's party view is very strong. That we understand, but respecting one another is primary. It's very primary, and we must speak straight as leaders. We need to respect one another and approach this conference, which is so well organized, with that dignity which it deserves. Number two, the issue of capital punishment was raised in good faith. We have engaged this issue over many years, many years. Now, it's an issue on which I don't think there will always be consensus. There will always be points of differences, depending on points of departures. But our own experiences as black people, was that people who were hanged were black people who were hanged for believing that they believe in human rights. That's why they were hanged. Mandela was in jail because he fought for freedom. There are many comrades who were hanged because they were guerrillas fighting for human rights. And many people who are very innocent were hanged. The risk of hanging innocent people, if you bring back capital punishment, is very high. And once you hang me, you cannot unhang me. I'm gone. And you realize you were wrong. I'm hanging there, you put me in the grave. So the mistake of capital punishment is that it's not correctable. And we have seen that in this country. I said in my input that Comrade Thabo asked me to go and talk together with Comrade Maduna, Comrade Zuma and others to say to the regime, stop the hanging. But the ANC never believed in that process of hanging people who believe in human rights. And there are other things people could believe in. Why hang them? A democracy calls upon different points of views. It does that. It was Rosa Luxemburg, if you know your history, political history, who said to Lenin, Comrade Lenin, democracy means your duty to defend my right to differ from you. That's what democracy is. So we should defend the right of other people to differ from us and not feel offended because someone differs from us. I'm not giving a political lecture, but we're born to respond in that manner. That democracy allows different types of views, and democracy is noisy. Let us have the noise with respect. So Ubuntu is paramount to all of us. What should characterize us is Ubuntu. All of us, how we relate to one another, young or old, we should relate to others that way. The issue of violence, I'm not likely to entertain the issue that slants to one party or the other. But South Africans, let's commit ourselves on the 29th to vote and accept the voices of the people. All of us. It doesn't matter how the people judge us. Let's accept the voice of the people. We need a free and fair elections in this country. That's what this constitution is based on. We don't want to hear little voices of violence. Now, some people are complaining. You talk like this, but people are being killed. There's premeditated murder. We've got law enforcement agencies. We've got the police force, the intelligence, the army, and everybody. They must go and do their work. They must investigate crime and bring the murderers or the criminals to justice so that we can stabilize this democracy. We cannot allow criminals to dictate how we should proceed with our democracy and define our actions. They must be arrested, they must be locked up out of society. So I agree with the sentiment you're expressing of being anti-violence. When it was time to carry arms, some people did not, they ran away. They left us alone in the forest. Now some guys want to pretend that they're very brave. No, we're not convinced. We're not convinced. We must respect one another. This is the time for peace and stabilizing our democracy. Freedom of speech. Freedom of speech is very important. And I've quoted Rosa Luxemburg. Defend my right to differ from you. That is democracy. Thank you.
We will now ask Mama Uzonke Majodina on that issue of xenophobia.
Thank you, Program Director. Just a few words on xenophobia, which is part of this conference because it's about racial discrimination and other related intolerances. So, to the question that was raised, I can't quite remember now, but there is xenophobia indeed in South Africa. But I take a more, not a personal take on xenophobia, me hating a fellow African from Zimbabwe or wherever. I'm talking about systems, institutionalized racism, and of course it's now institutionalized xenophobia. It's about resources. I didn't have time to go into the economy of discrimination because it's really about that. I don't think we hate Africans from other parts of the continent. It is because there are limited resources. Remember, apartheid put blacks in a box, and we could only access certain jobs and not others. But these were mainly low jobs, not high-profile jobs in the corporate sector and so on. So when then the new dispensation came, a few of us were able to climb up the social ladder, leaving many other blacks at the bottom still. We do menial jobs such as, how can I put it? Well, menial jobs, that's what it means. Very, very unimportant. But during apartheid, that's all we had. Now we have the opportunity to improve our stations in life by getting better remuneration and so on. But the crux of the matter is that we have been boxed to certain jobs which we don't want to do anymore, actually. Most South Africans will tell you that I can't be collecting rubbish for this township. And so the townships and South African Africans don't want to do those jobs. They consider them beneath them. So hence, I'm trying to say that xenophobia is more an economic problem than a personal problem. We may say they're taking jobs away from us, but it's not as if I don't like my neighbor who has rented her home to Africans coming from Cameroon or wherever. So I just wanted to explain that xenophobia in South Africa is really driven by economic forces more than anything else. It's not as if I don't like this person, I don't like that. It's about resources and how I'm going to make a living. And if, as I said earlier on, we have been conditioned into racial thinking. So that racial thinking has now affected even the way we look at ourselves as Africans. Hence, we don't call xenophobia racial discrimination. It's discrimination on the grounds of nationality. I hope I've explained a little. I don't want to take up your time to lunch.
Our last respondent now, Umamu Geraldine Fraser Mlegeti.
Thank you very much. I actually think that all the questions have really been responded to because it's in large themes. Secondly, a number of the issues that have been raised will be discussed in more depth over the next few days. So I think there'll also be a further opportunity. I wanted to lift two things. The one was, there was a young woman who spoke about Ubuntu. And I saw that as a statement around what we appear to have lost. And I think we should look at how we regain that, how we're able to recover virtually the whole issue of Umuntu, Ngamuntu, Ngabantu. Ek is 'n mens deur ander mense. My humanity is linked to the broader humanity. Apologies that I got it so badly wrong. So as I conclude this, I want to just conclude by going back to Gramsci, where he said, what comes to pass does not so much because a few people want it to happen, as because the mass of citizens abdicate their responsibility and let things happen. So I think the purpose of the 3 days as well is to ensure that we don't abdicate as citizens. And hence the points that were raised by my fellow panelists. Let's look very closely at what can and should be done, but also let's accept that there will be instances where we differ, and we should agree to differ. And differing doesn't mean conflict. It also means that we are willing to have real engagement in order to arrive at conclusion and some consensus on issues. Thank you very much.
Being a program director, you are trapped between panelists, audience, and the hard place. Because we had to release one of the panelists, hence, among other things. And I want to apologize to the 13 persons who waited patiently and we did not take them. And they understood, because we still have 2 days. I also want to suggest, DG, that when we come back, when you have audiences of this size and you want engagement in a meaningful sense, we must talk about the rules of engagement. How do we do it? When, how, what is the time allocated? And what happens when certain people are not given a chance, because that will happen. I didn't even give a chance to my friend here, Miles. And I'm sure we will have a truth and reconciliation moment during lunchtime. I ask the DG now to come and make announcement for that nourishment. Let's put our hands together for the panelists. Thank you.
Thank you very much, Prof. Miles gets a lot of opportunities, even on radios, to talk and so on and so you won't mind. First announcement, we have glasses. Someone has misplaced their reading glasses. It might also, they might be helpful during lunch as well, because you might end up eating something that you don't eat and create all manner of problems. So please just come forward. The only thing I'm seeing here is just written made from, if in case it helps to differentiate it from others that have been made in other countries. We're going to break for lunch now for about 50 minutes. I'm sure 50 minutes is long enough for us to have lunch and come back to debate the land question. Minister Togo Didiza is here, and Professor Tefo is here. We'll give Minister Didiza a good 15 to 20 minutes to give an account of the past 20 years without disturbing her. Then you can have the panelists participate and open the floor. I've been advised that the colleagues that are seated just behind the cameras from that point, there are ushers standing there. If you can see those ushers, you are requested to move out to the a thatched roofed place called Serengeti here. That's where the lunch will be served. And I was advised to request that you start moving before the judges, the ministers, and the excellencies, ambassadors, and high commissioners here, who will be directed to move to a different place. So those ushers there, can you lift your hands so that the colleagues at the back can see you? You are then requested to move out through the exit doors to lunch on this side called Serengeti. It's a thatched roof place. And those of you who are not seeing ushers in front of you, it means you remain seated, because you're going to go to the back of the auditorium for lunch, and 50 minutes should be enough for us to be back at 3 o'clock. When we come back for lunch, and all of us having taken lunch, we'll give the ground rules. We wanted to be liberal. But just a reminder to many of us who are here, colleagues, that in this country, many conferences have taken place. 1909, there was a conference, a very exclusive conference, and it resulted in the formation of the Union of South Africa, but the majority of the people of this country were excluded. They had another conference that resulted in 1948, the introduction of apartheid. They had another conference that resulted in the 1961 South Africa becoming a republic. All of those conferences excluded the majority. But the conference that took place from 1990 to 1993 was very exclusive. So this is a historic moment for all of us as well, post the dawn of democracy, reflecting on 30 years. Then the question will be, are we going to be the generation that has a 3-day meeting, shout and howl, and not come out with a concrete, cogent, and progressive program of action? So I just want all of us, even those that are moving out to lunch, it's possible that, the biological effect of being hungry sometimes has a tendency to temper with our intellectual appreciation of conditions sometimes. But when we come back from lunch, that will have been, Dr. Mutsalidi is here and Dr. Pasha are here. I think scientifically they can confirm what I'm raising. So, but when we come back from lunch, all of that will have been sorted. So colleagues at the back, please clear and go to lunch so that, because the people that are seated at the entrance, they will ask you difficult questions, whether you are a judge or you are a minister or you are an ambassador or former ambassador or a facilitator. And when such questions are not answered in the affirmative, it may not be nice. Okay, Excellencies, may I request those of you who are seated here, your lunch will be served at the back. If we can then proceed to the back of the auditorium. Thank you very much. And we thank the panelists and all of them here, the participation and the facilitator.
And also someone has left their A
and they will do an assessment of the progress in land restitution and security of tenure. Colleagues here in front, Advocate Sherin Said, Dolutando, Zonbiza ngamagama manje. Okay, all right. I would like to invite Professor Lisiba Tefu, who is going to assist us with the facilitation of this panel, to come to the podium and start the discussion. We are 5 to 15 minutes behind schedule now. We were meant to start at 10 to 3. We are now 5 minutes past 3. So, Prof, I invite you to proceed with the panel discussion.
Dumelang, greetings, good afternoon, goeiemiddag, Aslocheni. One of those difficult sessions where people have had, they've not reached their bodies, but that is fine. You want to change the world, you start with yourself. You want to change South Africa, you start with yourself. I heard there was a lot about Emil Cabral. And I'm deliberately starting this way because we have been talking, by the way, for almost 30 years. And we might have spent over R1 trillion just talking. But I'm happy we are here today to take stock of how we have gone with the talking. And I hope that in the limited time I still have under the sun, I won't find us still repeating the things that we said. There was a lot about Emil Cabral, but let me also say something about him, because consistent with, if you want to change the world, start with yourself. Emil Cabral said, each generation must, out of its obscurity, identify its mission, fulfill it or betray it. What's your role? Where are you? What have you done in the past 30 years? And what are you going to do in the remaining years of your life? We have identified a mission. The founding parents gave us the batons. Are they happy wherever they are? Will posterity later on say, indeed, when the baton was passed on to us, we did what we were supposed to do? Or are they going to spit on our graves? I would hope that when that day comes and they pass by your grave, they will doff their heads and say, here is interred the bones of one of those when were privileged, left a mark on the sand of time. We are about the land question, and I do say, indeed, the struggle was not for air-conditioned offices, was for the land. Land, as we have it, indeed is a means for social production and reproduction and statehood. There can never be a state without land, and there can never be a state without a nation. And the founding parents gave me 3 basic values that if you follow these ones as they undergird the Constitution of the Republic of South Africa, you certainly will arrive at that promised land that we envisaged when we were crafting this Constitution: reconciliation, nation building, and social cohesion. I've got 3 eminent speakers here. The first question I would hope that they would address, including your good self. How far have we gone in land reform and agrarian transformation in the past 30 years? Number 2, land restitution. Did we succeed or did we fail? Either way you go, motivate your answer. I'm a primary school teacher by profession. So either way you go, motivate your answer. Number 3, How many of us here know about the Shadrach Guto Land Commission, commissioned by the Republic of South Africa in 2014? There is one thing in particular that we have not dealt with and we have not addressed, and I know you shy away from it, but I'm not one of those. I have my future behind me. So when I speak, I don't censor myself. In that, Shadrach Guto and them in that commission, they said, it can never be correct for foreigners to own land, but they can enjoy the usufruct. The lawyers are here. The usufruct, the right to use but not to own. It may sound unpalatable, but if you don't confront it, 30 years down the line, you'll still be talking, and the natives on the ground will still be restless. Can we also talk about that, right? Western Cape is inaccessible for many people, especially of my color, precisely because by far the majority of the foreigners are buying land and hitting the prices. Farms are inaccessible to the average man simply because they've been converted into game farms, and in the main are bought by who? Can we talk about these unpleasant things in the interest of advancing this nation and taking care of that small man on the ground? I would hope my colleagues here, the panelists, and your good selves will talk about this, some of these questions, and also propose a way forward. Because I would be happy when we leave here that we have a blueprint that can help us not to come back and repeat the same things that we said yesterday. Now, the first person who's going to speak is someone I've worked with closely on this subject, in the country and outside the country, by the grace of UNISA. We have had over 10 conferences on land, and we are published extensively. That's Minister Tidiza, who was doing research, and one of the founding persons of Achimafeje Institute that specializes with the land question. And then she's now doubling up again as a minister, and I would hope that she will address, especially, how far are we? Can you critique, ma'am, Honorable Minister, critique the 30 years of land reform and agrarian transformation? Can we give her a round of applause, please?
Thank you very much, Professor Tefo. To my fellow panelists who are here with me, to the chairperson of the NCOP and House chairpersons that are here, members of parliament, members of the judiciary that are here, I'm happy that you're still holding the fort. Some of them I had the honor of interviewing while I was in parliament as a member of the Judicial Services Commission. I would also want to recognize the various representatives who are here from the various communities, the land activists, the traditional leaders, the Khoi and the San leaders that are here with us, and everybody in the House, and academics that are here, and the legal fraternity that is also here, given that this conference has been convened by the Ministry of Justice, who have got a very close relationship with yourselves. I must say that as we reflect on the 30 years of freedom, as well as how we have dealt with the issues of human rights arising out of our Constitution, particularly the Bill of Rights, Section 25 being one of those, which deals with the issue of land as well as property. To me today, it's a very interesting day because we do so when the President of the country assented last year to the Land Court Bill to become the law. And this is very instructive because the Land Court Bill was one of those institutions that are set up early in our democratic dispensation to deal, among others, with the issue of the land claims. And I would like to thank, and all of us to remember, one of the pioneers, Justice Bam, who actually led this court for some time. In the same vein, I would like to honor some of the justices who availed themselves when asked by their judge presidents to be seconded to the Land Claims Court. As we know that at the time, the Land Claims Court was not a full court where there will be permanent judges serving in it. I'd like to thank Judge Mir, who has really, through thick and thin, steered this institution to where it is now, where it will be transformed to be a full court. And one of the interesting things about this transformation is that it would help us as a country to develop the jurisprudence on land matters and be able not only to deal with the land claims issues, but traverse and deal with all other land-related matters. It is also an important day because in the 5th administration, government had decided to listen to some of the reviews and critiques that have been done about the non-coordinated manner in which land reform in South Africa has been handled. And therefore, there's an interministerial committee chaired by the Deputy President, which brings a number of ministries together to ensure that we can address the issues of land reform and all other land-related matters together. Today we're here to reflect on the journey that we've traversed as a country coming from 1994. What have we done? I wish to say that the first decade of our freedom was about laying the foundations and putting the institutions in place, such as the Commission for Land Restitution, the Land Claims Court, but also other legal frameworks that will start to really put meaning to what Section 25 said in terms of protecting the property rights, as well as instructing government to undertake land reform in order to reverse the inequalities of land ownership and land access. It was during this period that a majority of communities and individuals lodged their land claims in accordance with what our land policy framework was saying, as well as our constitution, that those who were forcibly removed and dispossessed of their land as a result of the 1913 Native Land Act and other subsidiary legislation such as the 1936 Land Act can actually claim their right to be restituted accordingly. And they would have to choose amongst the three forms of award, where land which they were removed from is available, they can get it, and where that is not available, they can get alternative land, and if they choose, they could ask for financial compensation. As we sit here today, almost 3 million South Africans have benefited from the land restitution program, majority of whom have opted for land restitution and others alternative land, while others chose financial compensation. It is in this process where I think our land policy and our constitutional framework was actually tested. Because while Section 25 outlines how the state can actually address the issue of land reform through legislation, or also ensuring that they expropriate in the public interest, however, following particular frameworks such as just and equitable, the history of ownership, and so forth. These actually, in practice, posed some of the challenges because where there are no records of how that land was actually valued at the time and now subsequently it was purchased, it became even more difficult how you address the issue of historical values. Without any clear valuation prescripts of how you define just and equitable, it was very difficult. While we can all appreciate that just and equitable means you cannot profiteer from such transaction, but if you do not have frameworks and measurements to do so, it becomes futile. And that is why, if you were to look from 1994 to date, a majority of the land claims processes in terms of acquisition of land, more valuation has veered towards market values, which has actually increased the cost of land reform in our country. No one would have thought that at the time this would have been a challenge. If one look at what the Reconstruction and Development Program said in 1994, that within 5 years, the state would have transferred about 30% of agricultural land, it actually became clear that it was not possible to do so within first 5 years. However, we have continued, even in this difficult trajectory, to make sure that land transfers to those who are historically disadvantaged is undertaken. What has been the challenges to those who have received the land? Most of the people who receive their land with minimal grants have not been able to utilize that land productively as they must. Land governance have also been another challenge, as it is reflected through trust and communal property associations, which are the instruments around which the people chose to actually manage their land collectively. And I think it posed the question for the future. What should be the role of the state when it has transferred such land to communities to make sure that they can be mentored and they can be supported, at least for the period of 5 or to 10 years until they can be sustainable? How do you make sure that communities are able to navigate on issues of community dynamics, but also on disputes that may arise about the choices of how this land may be used, in order for them to find a balance on ensuring that that land is accessible to all, but at the same time, it benefits the community? There are success stories, however, in this regard, where some of the communities, like the community Agamafu in Mosel Bay, who today are indeed landowners and are benefiting from that land, who have decided to make sure that as communities, they are trained, but also they divide amongst themselves the responsibility on the land management and its use. And they are able, through their land ownership, to actually create employment not only for their community, but also of surrounding communities. Matulu is another area of success. There are many others that one can cite where such benefits are actually visible. But there are also challenges in some of the communities. In mind, it's areas such as Zebediela, a very good estate that was transferred to the community with minimal support as settlement grant to make sure that they continue to actually work that land productively. However, we've seen the story of Zebediela not once or twice where there has been a collapse, the state come in, the community choose a partner to work with them, and it doesn't work well. Which actually, in my view, going forward in another 30 years, we need to reflect how best do we support those communities who have received their land either through restitution or land redistribution. It is also important that as we develop our jurisprudence on land matters, we also tease and see how we could take forward the work of the judgment that was made on the Msiza case by the Land Court to actually look at issues of just and equitable compensation. As part of the processes going, from 1994 to date, there had been questions raised about the way in which we deal with the willing buyer or willing seller in a manner that the state can effectively intervene in this process, where it can actually assist those who are the beneficiaries of land reform to be able to get a fair price in areas where compensation has to be given to those who have land to date. I want also to say, beyond this, the state has created an enabling environment where people like yourselves and me and others have been able to go to the land market where else we were not able to do so before. So overall, when we assess where we are today, we can say even though we have not reached the 30%, but we are in the region of 24% of land access in South Africa by those who were historically disenfranchised. Chairperson, the issue of tenure security, as it has been indicated in the program, is another area where we've tried to make some strides. In the legal framework, we've put in place the Extension of Security of Tenure Act to protect the rights of occupiers who are workers on the farms. Also, the Labor Tenants Act, particularly those people who were tend to be laborers in the land of their forefathers and foremothers. Success in these areas have been somewhat slower than what one would have loved to see. In first instance, the way in which the legislation has been carved is such that it is demand-driven. So if somebody doesn't apply to be assisted as a claimant of labor, tenant, or as an occupier as part of extension of security of tenure, they are not able to actually access the support or the interventions from the state. And in my view, this is one area where we're found in areas such as the Western Cape that the state has somewhat followed where people have already been evicted. And I'm sure the colleague who will be dealing with the issue of women on farms will actually articulate this further. Even in the instance where legal representation have been found, because of the challenges of not having a very rigorous jurisprudence on land matters, you have found that some of these cases have been lost on technicality, and sometimes they've been lost because in the way in which presentation has been made, working with the claimants, have not articulated the challenges that these communities have faced. But that doesn't mean we have not sought to address some of the issues. For instance, in communal areas, we have worked with traditional communities to make sure that through the land donations as a result of the state land disposal policy, they can be actually to develop those communities working with the state. Last year, we had a conference looking at land administration in communal areas, at a conference which was held here in this very hall, looking at how we can, as a state, divest our ownership of land of communities and give it back to them. And I'm saying communities because it is instructive that traditional leadership have always been custodians, not owners of the land of the people, but custodians of that land to ensure that the community's rights to land are actually protected. We're continuing on that work because in my view, it is very important to make sure that we do not perpetuate our past on how people remain on the land that they still technically are subservient or are minors towards the state. Chairperson, you have raised an important issue. How do we address the issue of foreign land ownership? How do we create a dispensation that on one hand addresses the need for investment and participation while at the same time ensuring that the unalienable rights of South Africans as owners of the land is not emasculated rather. I think it is important that as we go into our 30 years of, another 30 years of democracy, we need to actually take on the recommendation of Professor Guto and others, because it's not only him. There are other scholars who have actually ventilated on this matter, and also examples in other jurisdictions. If you look at London, for instance, very few people own London because it's Queensland, they've got the user-fried right. But that doesn't mean they can invest, that doesn't mean that they can participate in the economy. And I think as South Africa, as we evolve in our democracy, this is one of the areas that we'll need to address. Indeed, to deal with the issues of land cost escalation in the regions of our country which are prime, at the same time ensuring that we can ensure that we create a clear dispensation that would not scare your investors in our country that we so need for our development. I wish, therefore, to thank you, Chairperson, that you have given us this opportunity to reflect a bit on the journey that we have traversed, and I'm sure when it comes to the questions, we'll be able to clarify further. But as you had said, these were the opening areas for us to tease. Thank you.
Yeah, Honorable Minister, thank you. As you're talking, I could see Minister Lamola nodding with appreciation that his money is well spent as you were talking. Thank you for that. I think there are two things. Wherever you are, in any way possible, if you can help, restitution does take place. But CPAs fight and fight and fight, steal and destroy and damage the infrastructure given to them. If there are ways to influence in a positive way and ensure that that doesn't take place, it is them, it is theirs. But at the same time, I'm sure we can help, because sometimes it's pure illiteracy that speaks to that. Sometimes it's just pure criminality. I've seen it happen. And she quoted, unfortunately, it rattled me a little bit. I'm from that part of the world where there was a citrus estate that supplied the world. That World Cup that took place there in the East, the oranges of Zebediela was part of the prescribed vegetables and fruits at the time. As a young man studying in Europe, one day I was passing by the greenhouse. Those who have been around, what Atemasondo, they would know. There would be a badge, a piece of paper on an orange written outspan. If you are in Japan and you buy an orange, you see outspan, you know it comes from South Africa, it comes from Zebediela. But today is a sorry state because of the infighting. Maybe they need more support. Thank you, Madam Minister. I'm going to call Dr. Paraza and then also to share her thoughts. Can we give her a round of applause, please?
Thank you, Chair. My name is Gaino Paraza. I'm with the Public Affairs Research Institute, which is affiliated with the University of Johannesburg and the University of the Witwatersrand. I would like to thank all the honorables who are here represented, and specifically the respective minister who's here. Thank you for gracing us with this opportunity. So I'm here to talk about land restitution. And because I have 10 minutes, I'm going to speak as fast as I can. So in terms of land restitution, I think I will just remind all of us that it was a program that was put in place to replace land that was lost for people who were dispossessed of the land as a result of racially discriminatory laws or practices. And this platform was supported by various pieces of legislation, which include the 1993 Interim Constitution, Section 25(7) of the 1996 Constitution, and the Restitution of Land Rights Act. I was asked to talk about what has been the progress. I'm not a quantitative person, but I'm going to do my best from the data that I've seen. There was a recent evaluation report of the land restitution, whose findings were that 94% of the old order claims have been settled. On the other hand, you find that other reports, for example, the high-level presidential report on land reform and agriculture, the panel, in 2019, noted that the government failed to meet targets set by the government. For example, to transfer 30% of total productive land by 2014, and to settle all of the restitution claims by 2009. So if you look at that, it's a monumental failure. But if you look at the first statistics that I cited, we are talking about 97%. And unfortunately, because these figures are not in the public domain for the statisticians and the younger people to do their permutations. The jury is still out. And also when you listen to the presentation by the minister, and I think other people who come before me, people talk about different things when they talk about the indicators of success. So for example, if you're talking about SDGs, say the land indicator is SDG 15. There are indicators there, maybe 14 of them. So maybe we need to do the same with this restitution so that we say, what are we talking about? Is it in terms of land successfully registered to claimants, people who have moved on the land, number of court cases settled? What are we counting? Because it's possible that we could be counting apples and oranges. And from that point, it's like the Bible or Google. Everybody can prove anything. So it's difficult to say that have we are we making progress or are we just stuck? And another statistic by a late comrade and activist, Constance Mohale, she was emphasizing that Mpumalanga and Limpopo have the largest number of land claims that are still to be settled. So just from these figures alone, because a lot of people trust figures, there's a lack of trust, there's a lack of consistency, and so the jury is out. But having said that, there are several recommendations that have come. One of them is to ask for the government to accelerate the finalization of the land claims, especially the old order claims, which must be prioritized because we have already missed the deadline of 31 December 1998 as required by the Constitutional Court. So there's a need to speed up this. And there's also an issue of tenure security for the beneficiaries of land restitution. I don't have the figures, but if you look at what is the entity, what is the terms on which the land restitution claimants get their land, those who get a freehold title are few and far between. And because of that insecurity of tenure and that instability, it sets off its own domino effect of problems. And then in terms of the department itself, besides the reconfiguration that it has experienced, there's a declining capacity. At some point, we can even talk about a stagnation in terms of the work of processing the land claims. I understand they are struggling with resources and capacity to provide post-settlement support. They also have diminished financial, human, and technical resources. I was listening to somebody when I was preparing for this, who was saying that at one point, the Commission for Land Rights did not have somebody who speaks Afrikaans. And can you imagine what that means for the documents that were submitted from the 1920s? I also have been doing a lot of work with the CPA in the Richtersveld, where English is not the majority language of the people there. So that is just another highlight of the challenges that they face. There's also the issue of the entity, the receiving entity, the CPA. There is no shortage of problems in terms of instability, volatility, caused by so many issues, which range from the membership, the legal status of the entity, the leadership. If I use that CPA of the Richtersveld, between 2010 and 2009, there were at least 10 court cases by the community members versus the community members. So that is just highlighting the level of instability. And then the CPA also has a lack of technical capacity to manage the asset. Again, if you talk about that CPA in the Richtersveld, they have one of the biggest land claims in terms of value, where they have inherited a diamond claim, which was previously run by DBS. And one of the solutions that is being proposed is that they set up 10 corporate companies. Can you imagine imposing that on a formerly rural subsistence community? I don't know, we would have to have a miracle. So the recommendation is to sit down, the people who have experience and insight, to think about an alternative, sustainable, workable entity to deposit these assets into. Otherwise, it's just going to be an ongoing struggle. There is also an issue of water use rights, because in restitution we talk mostly about land, but if you don't have access to water and or the water rights, that project is dead. Somebody was talking about the orange farm just now. Water is a real challenge. There is also a solution in terms of, I think government has begun to soften its attitude towards the private sector, civil society organizations, and out of it is some promising initiatives that are coming out. For example, the work that has been done with Vumelana Association, which have been providing a technical know-how. They've also been mediating in terms of mobilizing financial resources to stabilize and support the CPAs, and also provide access to markets and support the development of emerging farmers. The civil society organizations like ourselves are producing knowledge, are also leading in terms of innovation, and providing technical and human resource support to the CPA. Lastly, I'd like to say something about the law. I'm not a lawyer, so I apologize to all the lawyers in the room. But when people talk about restitution, there's always some this versus this, this versus this. And it reminds me of a conversation that I was having with a late colleague, Constance Mohale. Most of you know her. They had just won a case versus the state, the traditional Cohen-Son bill, and she was voicing a frustration that communities go to court, they win. It's a lot of money, it's a lot of time. The status quo is maintained, nothing changes. So my parting words would be for the department and the stakeholders to think about, can we broaden the way in which we think about solutions to support the land restitution process? What institutions and frameworks must we put in place to complement the institution of the law and the courts? Because so far it has yielded negligible returns, if I may say, to labor and financial investment. Thank you.
Thank you. It's clear that it was a scholar, a researcher who was talking statistics, and some of us start to be frightened by numbers or get lost in the process. But we can't move forward unless we have got scientific, well-informed research and empirical evidence to support what ought to be done. Again, you come back to the issue of the CPAs. I don't want to belabor this point, safe to say. It's unfortunate that indeed we are our worst enemies. After every 100 or 70 kilometers, you will find that there is a TVET college. After restitution, people get the land, but they don't use the students. They don't use the institutions within and around them. And they try to do things that are not qualified or capable of. Yet there is free service. Bana barena, our own children. In the morning they wake up, instead of giving them experiential programs so that they can also benefit and we benefit, we don't do that. Can we go back and talk about these things in our respective communities? Because the CPAs are dysfunctional, but yet there are resources out there that can help turn things around. I'm going to call Dr. Lowe, who's going to talk about women and farms. Doc, welcome and thank you, ma'am.
Thank you. Correction, I'm not a doctor. So thank you, Minister Lamola, all members of Parliament, dignitaries, and all protocols observed. So I'm from Women on Farms Project. We work with women who live and work on commercial farms in the Western Cape and the Northern Cape. And the issue of land is central to women's struggles, women who lived on farms. As Madam Speaker was saying earlier today, that the Freedom Charter was sort of a precursor to the Constitution that we celebrate this year and our democracy. And one of the clauses in the Constitution is that the land shall be shared amongst those who work it. And for farm workers, they have yet to realize the shared land. Women farm workers and dwellers remain insecure, and they remain seasonal casual labor on white-owned farms, often from people who generationally own those farms. Now, Section 25 has two obligations. It protects the right of property and simultaneously places an obligation on the state to take active measures which will enable citizens to gain access to land on an equitable basis. Now, Minister Didiza elaborated on reasons why land reform and land restitution barriers to that process. But instead of quoting famous activists and scholars, I would like to quote from one of government's official websites as to their definition of land reform. And the website is not the Department of Agriculture, Land Reform and Rural Development's website, but it's the first website that pops up when there's a Google search for land reform. It says the broader term comprising both land redistribution and land tenure reform. Land reform often takes place within an even broader strategy of agrarian reform, a collection of activities and changes designed to alter the agrarian structure of the country. And the objective of agrarian reform generally are to improve the levels of agricultural production, both qualitatively and quantitatively, and to improve the agricultural producer's standard of living. Now, if this is our government's official understanding of land reform, then we're in serious trouble. Because its aim is, or its agrarian reform is to improve agricultural producers' standards of living. And according to the land audit of 2017, who still owns the majority of land, white owns and predominantly male whites own more than 26 million hectares of land, or 72% of the more than 37 million hectares of agricultural land. So what does that mean if white males continue to own agricultural land? It continue to place women in commercial farming areas in precarious positions of employment, and women's precarious nature is directly linked to land inequality and patriarchal control over land. So women's lives are located in a deeply patriarchal social, institutional, and economic system, resulting in utter dependence on male farmers and male partners, thereby increasing their vulnerability to gender-based violence, femicide, and limiting their choices to independent livelihoods and tenure security. This morning, we also heard about the equality clause, what has been done for women in the country, and we acknowledge lots of gains. But also, Domestic Violence Act and interdict means nothing if a woman must go back to a farm where the male partner is the main tenant or the main rights holder on that main occupier in that house, and where a male farmer tells her if she enforces the interdict, she must leave the farm. Similarly, we've had numerous cases where when police come to investigate or support women who are facing domestic violence, their first port of call is the farmer's house, and the farmer then informs police, oh no, that's nonsense, that's nothing. It's actually the wife that abuses the husband. And the police, who are supposed to be custodians of women's safety, are not forced, but they choose to leave the farm. We've started direct discussions and regular roundtable engagements with the police under the auspices of the provincial commander of police to discuss the ways in which women's services under SAPS offices are violated. We recently had a case that's currently under investigation where a male investigating officer refused to open and to investigate a charge of visible sexual assault. So that, as I say, that case is under investigation. Another consequence of land inequality and women's casualized labor is that they only work for certain times of the year, because agriculture is seasonal and there's only limited off-season work, which basically result in food insecurity. So the Department of Agriculture was, I would say, a protector of food security, supports and don't look at alternatives to commercial agriculture to ensure that there is food production throughout the year and that agricultural production does not result in seasonal hunger. Research that we've done in the Northern Cape showed that 88% of farm worker women are seasonally hungry. So we should not only look at land reform, but agrarian reform that's not profit-driven, but that ensures that women have food first and that women's tenure is secure. In terms of the tenure laws, Minister Diza also referred to ESTA, Extension of Security of Tenure Act, and although the act has been successfully used to stop thousands of evictions, there's still too many evictions. The last detailed study that was done by Nkuzi showed that more than 4 million people were evicted in the first 10 years of our democracy. As we celebrate 30 years of our democracy, no statistics exist because no follow-up study was done despite civil society asking government to support such a study. So in just one municipality in the Western Cape, the Drakensberg municipality, which until recently has been regarded as the eviction hotspot, 20,000 people faced court-ordered evictions in 2018. During our recent discussion with the Legal Aid's land unit, we've heard that increasing numbers and alarming numbers court evictions applications are happening in some of the other municipalities within the Cape Winelands district municipality. So the result of these court-ordered, and I say ESTA evictions, is that there's a lot of things happening and that but results in people ending up on the street. And the minister can also say, because we've referred cases to our office, where families, after being evicted through the land by evictions that were ratified by the Land Claims Court, families end up on the street. In that case, the minister intervened to ensure that people don't spend the weekend outside. But the following week, there was a similar eviction. This morning, a similar eviction came through. Court-ordered evictions ratified by the Land Claims Court where there's no emergency accommodation. So our question is, how is it possible that the Land Claims Court continue to grant or ratify eviction orders without familiarizing itself whether there's sufficient, adequate, decent alternative accommodation or emergency accommodation? So despite constitutional court successes and a challenging interpretation of ESTA and PI, these evictions and these violations continue to happen. Part of that is municipalities' lack of a mechanism, resources, and political will. Where we deal with these cases, we see that there's no uniform process and policy in dealing or providing emergency accommodation. One municipality will provide 4 zinc sheets and a few poles, and people must erect their own structure. Others would give an old army tent that doesn't protect people against the weather. We've seen last year when the Cape Winelands suffered heavy storms, that areas were flooded for weeks and people had to be accommodated in halls. So SAPS, Esther provides, and we've raised this issue a number of times, provides for criminal prosecution of illegal evictions. We are yet to see one criminal eviction. So SAPS are quick to assist the sheriff of the court to execute evictions, but where there's illegal evictions, they are visibly absent. Then the issue of the magistrates' courts. Also no uniformity in interpretation, and where Esther is a result of land reform and the constitutional section 25, magistrates narrowly interpret Esther and thereby granting eviction orders without looking and seeing, establishing whether it is just and whether families, especially women and children, will be negatively impacted. So to get to what is needed, land reform has three elements. It's land restitution, tenure reform, and redistribution. Coincidentally, this conference did not mention the third element of redistribution, and that is one area in which farm workers, especially women, can benefit from access to land in order to secure their tenure and also to produce their own food. Then 10 years ago, following the Dorans uprising, although the main claim or the main demand was for a better minimum wage, the other demands included that were raised, the other issues that were raised was the issue of farm evictions and eviction of children where families are separated, etc., etc. That demand, when then Deputy President Ramaphosa visited the area, he promised farm dwellers that there'll be a moratorium on evictions. And why moratorium? Until the issues are sorted out, until there's land for farm dwellers, farm workers, until the loopholes in Esther is sorted, there should be a moratorium on evictions to ensure that people don't end up on the street, that women and children don't spend the night on the street and face sexual violence and other kinds. We've heard this morning the fear of safety. So therefore we again reiterate farm dwellers, farm workers call for a moratorium on evictions. Then also there is agrarian, there is transformation in rural areas. But what is happening now is there's diversification of interests, and the land is being used. There's rezoning, and rezoning happens very quickly, within 2 months in the Western Cape. And then these security country lifestyle villages is erected, which basically means that all the farm dwellers on that farm is evicted and taken to a overcrowded working class area. So it is a new form of apartheid, economic, racial, class apartheid that continues to happen within the framework of our constitution and our laws. So, and for proper to ensure that women are safe, women are secure, agrarian reform needs to be a different kind of agriculture that's not dependent on large-scale, profit-driven, water-intensive, pesticides-intensive, but more small-scale and driven by what women and workers and small-scale farmers ask from below. Thank you.
Thank you very much, Mayor. Very clear and uncomplicated. And Again, it comes through the question of support, making sure that those who are given the land, they use it the right way. But the minister is here, of Agriculture, the Minister of Justice and Constitutional Development, the legal fraternity. You can hear as she's speaking, there are a lot of challenges that need all of you maybe to look at to protect that woman, that lady, that person who's being evicted and with nowhere to go, right? But she forced me to think about something as she was talking. The failure of land restitution. Would it have been to the extent it has been had men been excluded in the CPAs and it were only women? Food for thought. And I'm challenging the minister. Maybe it's about time you just exclude men when they form CPAs. Let's see what will happen in the next 10 years. I suspect we may do better because we keep fighting over power and positions, and the women are fighting for food for their children. If you look at Africa up north, the people who are really tilling the land are the women with children in the backs. Food for thought, Madam Minister, and after 5 years, I'll come back and take stock. And yeah, Dr. Chidi, it's your turn, sir. Welcome. Let's give him a round of applause.
I've just expropriated Prof. Tefo's pen. Good evening, everyone. It has been a long day. I am going to limit myself, and I'm going to request the chair of the session to alert me when I can notice that I'm going beyond the time that is allocated. Let me take this opportunity to greet the minister, the owner of this house, Minister Lamola. Thanks for organizing this event. You have brought great minds together. I was actually complaining that I'm suffocating there because I'm in the midst of strong women. But thanks for organizing the event. Let me also greet other members of cabinet who are here. One of them is the panelist. She has been introduced, she spoke with you. Judges, I see Chidi is here. Judge President of Limpopo, Judge Patudi. His surname is not Chidi. Patudi is his surname. And other judges as well present in the house. I'm from the Black Lawyer Association, the BLA, and I am with the Deputy President of the BLA. My leader, Kanyis, is here. The Secretary General, not General Secretary, has left us, Chris Mamatunja, and the President of the Student Chapter. They are very important. We always acknowledge them, the students, because we should bequeath great results of the work that we do to them, and that they carry the baton as they go on in future. And everyone present here, you've been acknowledged by many. I'm not going to repeat. You know, it's very interesting who works the land. If a student goes from Mpumalanga goes to the Western Cape, the first thing you need is accommodation there. And that is working the land, because it is the owner of the land, we call them landlords, who is going to accommodate you. That shows you the power of land, beyond what we call the tilling of land. And this very wall accommodates us, and for sure it's owned by somebody. That's working the land. So the issue of land should be very close to our hearts. I'll revert to this issue of the importance of the land later on as I progress in my presentation. Already a conclusion was made that we have failed insofar as reforms as to access to land is concerned. Well, of course, there has been some progress. It's not complete, total failure. The percentages have been revealed. And of course, we are mindful of the fact that it's 30 years since democracy. And we're still where we are. Well, the question is, going forward, how many other years do we need before we can register satisfactory progress and all say that The results we have registered are, or have borne fruit, have been productive insofar as what we want to achieve is concerned. Insofar as the program that we have implemented is concerned, which is restitution, you know, it's very interesting in my assessment, of course, the BLA says so as well. You claim land from one Van Niekerk, is one together with his family of 5 people, and yet you are 600. And you've never worked together, 600 people. That's where the problem lies, because these people are going to fight. Some of us are supposed to be beneficiaries of land reform because our communities have claimed land, but when you go there, you realize, you rather stay away from trouble because they are elders and you don't want to be, it's in rural areas, you don't want to be a troublemaker. So you stay away. But you stay away from something that you're supposed to be benefiting from, and at least, even if it's not me, there may be other professionals or people who are naturally gifted who may make very productive inputs in how such processes may benefit our communities. But you learn soon that you may even be physically attacked. So you stay away from it. Our take, and of course I think at a later stage we are likely as a professional body engage government on this issue, is to revisit the model. If a Niger can have 200 hectares, why do we think 500 people should have 200 hectares? Is it going to work? Has it worked? It hasn't. So we need to revisit that. Of course, we are a society that is supposed to be based on the advancement of freedoms. The Chief Justice was here, he highlighted this issue, and it's grounded in Section 1 of the Constitution. And it's very important because it says freedoms. It doesn't say freedom. So freedom includes what we don't like, perhaps because of how it was populated, economic freedom. It's important, economic freedom. I should repeat that we are in this wall because somebody owns this property, and that person is going to benefit. That is economic freedom, but it manifests itself in ownership of land. And you see land freedom there as well. So part of what we need to do is to check the preamble to the Constitution. Very progressive. We've got to be a society that improves the quality of life of each citizen. And of course, it comes back, free the potential of each person. And then it's linked with Section 1, the freedoms, dignity, and the achievement of equality. Got to visit those in reflecting over 30 years of democracy. And we go straight to Section 25 of the Constitution. It has parts there. The first is deprivation, subsection 1. You don't pay compensation when you exercise that. I'm happy the minister spoke about the Msiza judgment. There's a reflect all judgment and the FNB judgment. And the two FNB and reflect all are from the Constitutional Court. They show you, if you exercise deprivation, you don't have to pay compensation. Question has been, what is deprivation? The Western Cape experience of lack of water, there was a dam there, privately owned, it appears. Government exercised deprivation by not taking the land, because Section 25 is about property. You go and release that water through deprivation, because you don't take the land, but you benefit from a right that an owner of the land has. That's deprivation, subsection 1. Subsection 2, as you know, it's expropriation. It's linked with subsection 3. Expropriate, pay compensation. That's what it is. So these are two provisions you can use to interfere with land rights from a landowner or a person who controls land. And the third is subsection 4. It requires the commitment to land reform, but not only that, to reforms as to access to natural resources at an equitable level. Subsection 5 is central. Requires the state to facilitate access to land. Now, the question that you see on the program there is land rights. Let's assess where we are. Question is, do we have right to land? If you go to subsection 5, it's not there, you can't see it, it's not expressed. If the state has an obligation to facilitate access and it doesn't do it, what follows? You've got your Groot bomb judgment, late 1990, 2000, you've got your Superman. They say if the state fails, you compel it to exercise its functions. And how does it do it, the state? And I'm talking about subsection 5 of section 25. So if you read it, in my view, and in the view of the BLA, we might develop a theory that shows that indeed, in the end, this right may be enjoyed. Of course, there's a right to development under the United Nations. You can consider it under that context as well and develop a very nice theory on the basis of which later on we might be able to cause that right to be enjoyed by members of the public. I will jump and go to subsection 8 of section 25. It says the following. If there is any impediment in section 5, this is what it says. It's English there, but this is what it says. If there's anything that hinders you from facilitating access to land at the state, what you do, you regulate the exclusion of that impediment. It says anything that stops government from facilitating access to land, do away with it. That's what it says. Now, what is one of those? It's the money that has to be paid on compensation. Of course, there could be other impediments. So you regulate the exclusion of payment of compensation through a law of parliament and use that law then later on to facilitate access to land. What do you use it for? There are 4 categories. Land reform, reforms related to land. That's textual wording of the subsection. Water and reforms related to water. Now, if we stick to land and we ask, can you ever have the construction sector without land? No. Then you can use this subsection to transform that industry. The industry, tourism. Somebody was telling me the connection between land and telecommunications, very complex, but you can't have the tour without the land. So in any sector that you want to go into, and this is a textual reading, I'm not talking about a purposive reading of the act, what the drafters of the act intended to achieve. If you limit yourself to the content of subsection 8, most of our solutions are there. For all industries, I spoke about this wall, is hospitality. If I want to go into this, to own this big piece of land, somebody has got to pay for it. So you use expropriation as well as the deviation from the requirement of payment of compensation to cause me and or any other person to have access to land in order to go into a land-related industry. Of course, is still based on land. The last point that I want to take, so our approach as the BLA is that we'll engage as we go on, and we hope that government will be open as it invited us here to engage on this issue. But for the purpose of this conference, notes are that if you focus on subsection 8, most of the industries would be transformed. There's no reason why we can't transform. Our constitution is the most transformative constitution. Of course, there are challenges. But if we apply the constitution, we should not have problems. Of course, we are aware of the subsidiarity problems and what it may do, but the law can always be amended. After all, it's a common law principle that should not hinder the implementation of the constitution. Otherwise, we'll be saying a law from outside should come and frustrate us in the country. A subsidiarity principle is one of the challenges that we hope as we go on we'll be able to attend to. Now, the last point that I need to make, I hope I'm still within time. Okay, thank you. The last point that I need to make, when you solve a problem, you really need to understand it. And of course, our understanding will always differ, and we came here because we think we understand the challenge with which we are faced. In 1992, between CODESA and the multi-party negotiation process, there was a legislation that was passed amending the Expropriation Act of 1975. That legislation introduced a principle we think is from our democratic government, which is not. The willing buyer, willing seller. If you go to section 12, subsection 1A, Roman figure 1, you will see the insertion of that amendment in the Principal Act. So the point I seek to drive here is that whilst our leaders were trying to say what type of a process after the failed two CODESA processes can we embark on, in our absence in Parliament, a law was introduced, and that law says if you've got to buy land, somebody must be willing to sell it. We are stuck with that, but it shows you the challenge we are faced with, because genuinely when we are attempting to negotiate, law has been developed and we are stuck with that law. But what we need to do is to go back to that law and say, what is it that we can do to change this? And I'm highlighting this because it shows the frustration we are in, because if we were genuinely, all of us, committed to transformation, we can't be asking why it should not be happening. We can't be asking why land has to be taken from somebody and be allocated to someone else who has 300 hectares should not see a problem in allocating to me, for instance, and I need that land, 50 hectares. Thank you so much.
Thank you very much. Subsection, section, plus section, and section, and section. Right? Dada Chidi? Thank you for all the sections. Let's, what is very, sometimes I use English that I wasn't taught at school, but I just use it, Don't complexify the law. To a point, you, the legislature, have to engage the courts to interpret the law you have made because you no longer understand what it is. How many times have you been to court, forcing them to pronounce on the legislation you make? Please don't complexify the law. Make it easy for your own good and for the good of the average man and for people like me who are teachers, that when we talk to the students that we know what we are talking about, all right? But I don't say sections mustn't be there, let them be there. I think we have done very well with the panel. We have done very well. Senior Counsel Ngatobi is not here. And I'm going to give you a chance to at least pose 4 questions. But before I do that, as the mics are being prepared, I see in our midst, we have got a mobile encyclopedia that debated this matter and published extensively on this subject. While the mobiles are going around, I'm just going to ambush him and ask him to speak just for 2 minutes on this subject. I think I'm going to force my hand here. He's my former teacher and principal, Professor Mushenkondo. I have the right to command you when I'm here. Can you give him a mic and let him tell us why for 30 years he has been on this subject? Have we made progress or not?
I've known the chairperson for many years, for over 30 years. Yeah, my name is Mushenkondo, and I've been a friend of the chairperson for many years. And he also was my student. But I think, thanks very much for this session. I also want to congratulate the Minister of Justice for this occasion. It's most strategic and most appropriate. 30 years later, the question that we should ask fundamentally is what can we learn from our own past? This is institutional learning, and what is more important, your capacity to learn from your own failures. That is strategic, and that is where we are now. What I think I could say, and I won't be too long because we've been here for a long time, is that we went to Kempton Park, and then we said we are going to come together to resolve our problems. we came out with the Bill of Rights, which is the most powerful instrument to resolve conflict. Why is it that the Bill of Rights hasn't enabled us to solve the land question? Perhaps something has to do with the language of the Bill of Rights itself. Perhaps the language is ambiguous and is vulnerable to conflicting interpretations. I'm calling on conference to look very carefully, at the Bill of Rights. Let me give an example. Two principles drive it. The first one is choice. The second one is competition. If you are in a country with serious historical imbalances, what does choice mean for those who have and those who don't have? What does competition mean between those who have wealth and those who have no wealth? So those two principles, in no center as they look, might be the center of our problem. Something that makes it easy. We went to court as the ANC, and then we lost on the land question. Why? Where are the loopholes? The loopholes might be in the ambiguity of the Bill of Rights, making space for those who already have wealth and power. So I'm calling on conference not to worry about specifics. The fundamental, logic of the Bill of Rights and how it is vulnerable to conflicting interpretation. Let's go back there. Thank you.
Yes, yes, that is Professor Mushe Nkondo. He's a professor of English, but I can see that he doesn't want to complexify matters today, just making it easy. Right. Thank you very much. Here we are now. The mics, 4 questions only. I think I've got people who still have to, we have got another session, and with people who have to travel, especially to the border there, where the baobab trees are in my ancestral province. So I'm mindful of time. 4 questions, and the speakers will tackle them. Where do we start? All right, let's start here. I think in the name of minimizing confusion and contestation, we start here. We take 1, we take 2.
I'm here already, Prof.
We take 3. Then the last one will come from there. No. There will be no 2 questions this side or 2 questions this side or that side. 1 is 3. The last one at the back. Okay. Yes.
Good day, Prof.
Where is the mic?
I've got the mic.
Can you stand up? I can't see you.
I'm here in the middle, right in between the cameras.
You have already appropriated the mic.
Yes.
That's fine. Let's go ahead. Are you this side?
Yeah, I'm in the middle here,
no.
Prof.
Were you this side?
No, I was sitting next to the Prof.
You were this side?
Yes.
Okay, the next question will come this side. Okay, we have cleared that. And no preamble, just go to the question, please.
Yes, Prof, because of time. My name is Miles Budu.
Oh, that's Miles. Okay.
I have been in Inzile for quite some time, but now I'm back from Inzile. That's why you can see and hear me. I don't want to waste a lot of your time, but if there was enough time, I was going to, into the record, rehearse the poem of Minister Louis Farrakhan from the Nation of Islam called The Land. I've got very little time, but I would say very quickly, he came here in 1996, he went back and reported to his constituency, and he gave a speech about the land, and we converted his speech into a poet. Where Mugabe fought, he won, but never took away the land from the Caucasians. And those who fought with him came to him and said, look, brother, you will have to give the back land to us. But before Mugabe giving back the land, he was the darling of white people. You always there, friend, for as long as you're not a friend of your own people. But when Mugabe said we got to take back the land from the white farmers, I mean who had thousands and thousands of acres of land and black people have none, all of a sudden England and America turned down on Mugabe. Right now in South Africa, he said, Thabo Mbeki was reasoning taking land, and that never happened. When he came to South Africa, he got off the plane and he saw a man in chains. I didn't say a word. Later that day, he went to the Carlton Hotel. He saw me there. I didn't say a word. What was I telling him was, Minister Louis Farrakhan, I don't care damn what they say. We're still in chains. If you go to South Africa now, the land is still in the hands of the whites. The diamonds are still in the hands of the whites. The diamonds and gold are still in the hands of whites. And black people have none. And the white world has to pay. I thank you.
Thank you. Thank you. Miles, the problem is I didn't recognize you because your attire is incomplete. Yes. Thank you very much. Yes, where are we now? Yes. Thank you, sir.
Thank you very much, Program Director. My name is Mdu Shabangu for the purpose of this gathering, from KEOSA, that is Community Advice Offices of South Africa. I'm standing here, I'm wearing so many hats, but I will try to be very much to the point. And don't blame me, because the program director there was my lecturer. If I go must blame him, he's the one who taught me. Together with Professor Geshla Mushenkondo, you can blame them as well. Now, the point here is about the land. You know, when we speak about the land, it's a sensitive matter. I think much more engagement are required and needed as soon as now. Minister Didiza, thank you very much. Like I've said before that I'm wearing so many hats. I will say thank you very much for the work you are doing for the military veterans in particular. You are the only department in this country that takes care of the ex-combatants in this country. All the departments, we have been made to be their enemies all the time. And thank you very much. Keep up the good work. With regard to your other aspect of your department, you have mentioned the challenges that you are facing, but there is also another challenge that you might not be aware of. Your personnel, your staff, your officials. There are lands that have been finalized as far back as the year 2000. Nothing has happened between that period and now. You have said before that there are many things that have happened, but in terms of the percentage, I'm telling you, it could be less than 5%. I'm talking here about the land claims whose closing date was 1998. Still less than 10% of the land that have been finalized, of the land that have already been in use as we speak. But there are lands that are lying. There are lands that are making production on a daily basis. But there are claims that have been filed with your department, and nothing is happening as we speak. Some of the matters or some of the cases, we took them to court, and our clients won those cases. 10 years ago, nothing has happened. We are talking here about matters that have been filed before your office.
Point made.
22 years ago.
Point made. Thank you very much. Let's move to this side. Now, we have had two men speak. Then it's two women speak now. Otherwise, the Gender Commission might give me problems. Right? And it's this side. If there is a lady, we are ready for you. Yeah, a lady, good. At the back. And at the back, then another lady, then it's okay.
Thank you for the opportunity. Thank you for the opportunity to be here today. In the efforts to respect time, I'll simply say all protocols observed. My name is Disha. I'm an attorney from Indifano Kwazi, which is an activist organization and law center based in Cape Town that focuses on urban land justice. Urban land reform has notably been absent from the discussions today and from focused state intervention, despite the state's own projections that majority of the population will be living in cities, and acknowledgements that there is an urgent need to address urban land reform in both the high-level panel report and the President's advisory panel report on land reform. So my question to the Honorable Minister is, what does redistribution look like in an urban context, and how will the provisions of Section 25(5) of the Constitution and progressive provisions in legislation like the Government Immovable Asset Management Act and Spatial Planning and Land Use Management Act be activated and complied with to achieve urban land reform and restructure our cities to be more spatially just and accessible? Thank you.
Thank you. Okay.
Positive and Creation Energies once more. I'm Nicolene Trom from Umdung Abantu Foundation, which is a community-based NPO dealing with the social ills of the community, of which land is the vital piece of our struggle. I come from a marginalized community whereby most of the land is private-owned, and they do have dilapidated buildings, land that can be utilized to better the community for the upliftment and the development of the community. The community that I reside in doesn't even have a high school, and that perpetuates a high rate of school dropout, of which the land can then be utilized to build the high school. It doesn't have a clinic, which is one of other basic needs that is needed in the community. We had engaged with landowners, but they are not willing to come to the party, and the municipality at this point is helpless. Because the problem is that with most of the dilapidated buildings that are owned by these private owners, they perpetuate the high crime rate in the area. You talk of the gang rapes, you talk of the murderers, heinous murderers. They stem from these, and the owners know that they are not held accountable for the atrocities that are done through their land and their space.
Thank you very much. My name is Angelina Nyandeni from Basadi Bamokhale in the West Rand.
All right, I thought I said 2-2. Then is that the third lady? Because I can't see you where you are.
Yes,
where are we now?
Third
Are
lady.
we here?
We are here.
But it's number 4 or number 5? It's number 5, and we said 4. Anyway, because it's Madame, I
Yes,
defer to you.
Yes, please.
Yes, let's go ahead. Let's go ahead.
Okay, can I continue?
Yes, please.
Okay. As I've explained, I'm from the West Rand in Kagiso. As we are talking land, I'll just go in with one point and then go back to the GBV, as I'm representing Basadi Bamokhale gender-based violence. We are sitting on GBV because land is part of it also. Right now, I have a case I've just received whereby a child, the mother died, they were supposed to get an RDP, so now they are not getting that RDP because of the mother passed. The lady ended up being with a man that impregnated her. Now she's thinking of committing a suicide because she doesn't know where to live. So in Mokhale City, currently, we've been fighting about this land allocation to say, if you cannot be able to give us the RDPs, why not give us the land so that we can build for ourselves? So that is what we are fighting for currently. It's been up and down, but the municipality is not coming forth to understand what we are saying. Give us the land. If you can come to the West Rand, you can see people from other foreign countries, they've put themselves in open spaces, but us as South African, if we do that, the red ants are called. I'll go back to the GPV.
No, it's fine, ma'am.
Just one, yes.
Your point is made.
The last one about GPV. That was land. I'm finishing, sir, I promise. I'm saying, this one goes straight to Mr. Lamola to say, perpetrators are more taken care of than victims. Perpetrators are in jail and they get all sorts of care. They even come out with certificates, bachelors and whatnot. So my question is, what about the victims? After the court and there is a judgment, what happens to the victims? Because of they end up going back to another abuser. Thank you.
I can detect the passion in your voice, ma'am, and you are talking about a lived and not a mediated experience. Minister, you heard her. Yeah, we are going to start there and end up here. Doc, please.
Thank you so much for the questions. And I heard a lot of comments and requests which were emphasizing some of the points that we've raised about restitution. And I would just underline the need for data and empirically verifiable evidence to inform policy making and decision going forward. Thank you.
Short one, the urban exclusion of land processes. Our planning has always been based on what was inherited from the oppressive past. Oppressive past in a sense that the government policy currently focuses on agriculture and residents, and in farming as well as rural communities. Also what is missing in the midst is land reform in urban spaces. We don't have it. Why that has been so, some have been questioning. I'm not sure whether we are afraid to go into that space, but it's a very important space because people are migrating to urban centers and they don't do it necessarily because they like it. They follow opportunities. So when they come to town, they don't stay on the trees. They've got to have a place where they stay, and we have limited land reform to rural areas and farming communities. It's a very important issue. But to solve it, because we were not dispossessed of, in some instances, unlike the Skukunis and others who were taken from Pretoria and thrown away to Skukuni. Many others may not have stayed in urban centers, and restitution will not help them, that program, because you need to prove that your ancestors, or forebears, or parents, they stayed in a specific area and there's evidence to that effect. So if you rely on restitution, you will not succeed. What then follows is restitution. And unfortunately, redistribution, thanks for that, redistribution. Well, that is what we ought to be applying our minds to. Unfortunately, we have not done it. Obviously, also not limiting ourselves to urban centers, because if I've got to go and stay in Umlazi or any other place, when I get there, I must be able to have land. And that is something that in the African sense is done, that no one should be without land. Wherever you go, the traditional leaders will allocate land to you. Perhaps approaching the law from the African lens perspective, and not from the common law perspective. We might as well learn from that African principle that perhaps we start with women, and we agree that no woman should be without 1 hectare, regardless whether in town or not. And of course, women, they take care of us. We are here because of them. So if we start there, we would go very far. That's my contribution. Thanks so much.
To add to the question of women, I think the president this morning mentioned that land dispossession and the apartheid history separated families, but it was women that kept the families alive by planting and providing and producing food. So if we want to ensure the food security of this country, we need to ensure that women have land.
Thank you very much, Program Director. And maybe I must say that contrary to what the previous Program Director, Prof. Somadoda Figeni said, trying to be a rebel rouser for everybody to say, you know, the session that is coming will be heated, so let's go and eat. I must say that I experienced the opposite. I'll still have to assess from him what was his idea, or what did he sense that I missed in the process. I'd like to thank the panelists, but also the participants who had an opportunity to raise the questions on this important topic. And thank Prof. Mushe for the issue you have raised to say probably in the reflection that we're making, we might need to reflect on what we put in the Constitution, in the Bill of Rights in particular, and make an assessment whether in the interpretation and application, the way in which we understood what was said is correct. And if you look at Section 25, it's very instructive because on one hand, when it starts, it protects the rights of property for everybody. But that happens in the context where others didn't have any property to protect. So that's the first anchor. And then appreciating that reality, it then instructs the state to undertake land reform. And I've always said that's a contradiction in our Constitution because that's the balancing act you must make in how you actually undertake land reform in South Africa in the context of that constitutional clause. And I think that's part of the debate, maybe Minister Lamola, in the next conference, which will be solely on land, I'll propose, because today this session was very limited. So I didn't even have enough opportunity to canvass some of the issues that were raised by my panelists. And I would agree with Doc that the issue of data, it's important so that all of us can move on the same basis when we critique the progress that has been made or not made. Because as you say, if you look at the period 1994 to 1996, 1998 rather, that was a process of lawmaking on the one hand. Restitution Act was approved and assented into law in 1995. Between 1995 and 1998, it was a lodgement process of the claims. And it's important for me to appreciate that those claims were not just about rural claims. It was anybody who was actually dispossessed as a result of legislation of 1913 onwards that actually moved you from the land that your parents, your grandparents owned. It is only after 1998 that the Land Claims Court, on one hand, had to deal with those matters where there had been lodgement of such claims. The Commission on Restitution had to start during that process to look at those claims and start to deal with them from all over the country. And I must say that if you look at the first claims that were resolved, were actually a mix of both urban and rural. You would remember Sophia Town, which today is Triumph. It was one of the first claims that was resolved. But because communities, and not by any persuasion by the land commissioners, it was out of their choice that they felt they wouldn't want to go back to Triumph because it was already built up and it would cause another disruption. And therefore they opted for financial compensation. And I think it's important to remember that the Constitution, as well as the land policy, part of what it says in their preamble is that land reform must also deal with issues of social cohesion. So you can't miss that up in addressing this question. The other areas such as District 6, Alexander, Newlands, Petersburg in Limpopo, all of those were urban claims. East Bank, West Bank in East London were all urban claims. I'm using these examples to actually indicate to my BLA colleague that it wasn't just about rural. It was anyone, whether urban or rural, that those claims had to be addressed. And I think when we have to look at this matter going forward is to say, with the lived experience of 30 years, with the progress that has been made, with the challenges that are still remaining, how do we address, in the South African context, what we have to deal with in terms of land dispossession, be it restitution or redistribution? Because redistribution is being done. If you were to look at a number of municipalities with commonages post-1994, it was the instruments of redistribution that actually acquired land as commonages for those people who stay in urban areas who may want to subsist on agriculture or other land businesses in order for them to be able to do so, and utilizing the Development Facilitation Act. Similarly, some of those areas which were informal settlements are actually those areas which had been addressed as a result of housing policy, but also, again, state land donation to be able to make sure that those communities can actually have the land to stay. Some of those initial communities around Krugersdorp and around the West Rand. However, what has not followed through, which is what government has tried to sort in the coordination, is that those communities received the land, put up their structures, but there was no bulk services. So they become, slums, if I were to call it that way. And these are some of the corrections we need to do. The Expropriation Act that you referred to in your presentation, Doc, is Expropriation Act of 1975 as amended in 1992. That talks about the issue you are referring to, which is why it is being amended. Now it's with the NCOP to actually address all of those anomalies and give the hand to the state in its various spheres to be able to expropriate in the public interest and for public purposes. Because all along, our Expropriation Act only addressed public purposes. So you could expropriate if you want a road, you could expropriate if you want to have servitudes for electricity, you could expropriate if you want to build a township or a town, but you couldn't expropriate in order to give a community that is landless land in order for them to survive. So these are some of the issues which indeed I agree with you that our legislatures have to address urgently so that we actually improve some of these challenges. The issue that was raised by my sister around allocating land where maybe there is no resources for the RDP, yes, that has always been the policy. Remember that even in 1994, you had what was called people's housing projects. Those people who wanted to pull their resources together, government give them land and they would build their own houses. And that policy still continues even today as social housing projects by the Ministry of Human Settlement. And in addition, the state has publicly said that they are going to, as part of addressing the issue of land need in urban setting, give sites and service, and it has happened already in some of the areas in and around some of our townships, where people have been given sites with the numbers on their sites and they can develop themselves. And progressively, municipalities have given bulk services to make sure that those houses are actually having enough basic services. I would close, Chairperson, by saying some of the issues you raised earlier and what has come out from the conference participants as well as our panelists would require, in my view, another session where we would actually tease together some of these issues, collectively looking at our 30 years and say, we have walked this journey, we may be midpoint, but we're not yet there. What do we need to do further? But all of us would agree that progress has been made. It may not be to our satisfaction, but none of us can say we have not started to see the change in our lifetime, where those who were dispossessed today are the owners of their assets. Thank you very much.
My wonderful panelists, well done on time. If you want to change the world, start with yourself. Dr. Matthew Posa said, all of you without exception, you must put a badge here, as it was fashionable 10, 20 years ago. Many cars, especially where I worked, they always had stickers, I love Jesus, 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 Jesus. Now, here is a new face for the next 5 years. Put a sticker here. If you don't put it every day, at least every Friday or every Monday, once a week, that says, I am not, or, oh, doctor, let me just quote him verbatim. Thou shalt not steal. That is sticker number 1. The second sticker comes from Minister Fraser Moleketi. I am not a misogynist. And the last sticker, then I think, comes from Tefo. That one says, every Friday or Monday, I must say, what will be my bequest to posterity? What will be my bequest to posterity? Director General and the Minister, I think your money was well spent, but we still have another 2 days, but I'm happy so far. Thank you.
Just a disclosure, particularly because we have the members of the judiciary, those bags are not carrying anything other than the 30th anniversary edition of the Constitution. Okay, Prof and the panel led by the Minister and everyone, thank you very much for Minister Didiza. Yeah, we owe you the 1 day or 2 day symposium on the land question only, because many people did not get that opportunity, and we can commit here that we will work with you and at the cost sharing model and deliver the conference. Thank you very much, Prof and the panel. Someone left a pouch, a very posh pouch of eyeglasses. Judging by the name, I don't use glasses. It's called Ray-Ban. I suspect it's a posh of eyeglasses. Oh, the owner is there. You can come and get them, sir. Thank you very much. So yeah, for a person who doesn't use glasses, you may think Ray-Ban is an exclusive brand, only to find that it is not. But this. I have another pair of glasses, but this one is not in a pouch, so I can't tell the name. But really, for anyone who has lost glasses, you may please come and collect them. We move to the next panel without taking much time, ladies and gentlemen. The last panel of the day, that's on the role of the judiciary in the promotion of human rights. We are looking at judicial review as a tool of accountability. Panel members, if you may please ascend to the stage. Our facilitator is Commissioner Alcintile. Oh, you are here already, okay. Retired Judge Margaret Victor is here, and we have Advocate Romeo Tambelin. Romeo was just awarded Silk, I think 3 weeks ago. So it's Romeo Ntabeleni SC. We congratulate you. Thank you very much. The panel is here. I hand over to you, facilitator.
Thank you very much. Honourable Ministers, Members of Parliament, Judges President, Judges, ladies and gentlemen, comrades, friends. I've been very pleased and proud to be asked to facilitate this session. We're going to look at the role of the judiciary in the promotion and protection of the right to administrative justice and judicial review as tools of accountability. Now, you may not believe me when I tell you these are actually some of my favorite topics. I think importantly the role of judges, ensuring the implementation of the Constitution. I think our judges and our judiciary have been very important over the last 30 years and grow in importance as we navigate the complexities of a democracy with many stakeholders. The role of judicial review has obviously been super important in holding power to account. We clearly love our judges. We come to them all the time with our problems and ask that they solve them. I think litigation is actually our national sport, not cricket or soccer or rugby. We do like a bit of litigation in order to help us get where we want to be. And then there's the role of administrative law in ensuring that there is a rational, fair administrative process. So if I'm so enthusiastic about all of these aspects of the topic, you may then ask me, well, what about accountability? And I have to say that that is probably the sore point here, is a lack of accountability and a culture of impunity. And I think that's something that we are going to talk about. I'm very pleased to have this panel here who are just as enthusiastic about the topic as I am. And I'd like to start with Judge Victor, who is a retired judge from the Gauteng division and who acted, I think, in the Constitutional Court in a number of decisions and wrote some very important decisions. So I'm very pleased to welcome her to the podium.
Thank you, Alison. I know there are no preambles, but Minister Lamola, I must say to you and your team, this has been a fantastic conference. It's going to be a benchmark, the 30-year benchmark of our constitutional transformational project. Historians and political analysts and human rights lawyers will look at the contents of this conference and say, indeed, 30 years, look what has been achieved. To me, this conference highlights the remarkable quantum leap from pre-1994 to date. Of course, there's a lot more to be done, but we have to celebrate our success. I sense amongst our young people that here in the audience today that they feel that not enough has been done. Of course, not enough has been done, but I want us to look back and see exactly how much we have achieved. Our successes have been many. I have been in law for 40 years, and I've had the privilege and joy to experience firsthand the changes. It seems to me that what Tata Mandela said to us is, it almost seems impossible until it's done. Nothing is impossible. Well, for us human rights lawyers, all those 40 years ago, that was our lodestar. Our president referred to our lodestar. That was our leitmotif of human rights lawyers in those dark days of gross violation of human rights. In 1986, I was a young advocate at the Johannesburg Bar, and 5 young men were charged in the Alex uprising, the youth uprising. They were Mos Mayakiso, Obed Bapela, Paul Shabalala, Richard Mdakani, and Mzwanele Mayakiso, the brother of Mos. David Soggett was our lead advocate at the time, Norman Manoim and Amanda Armstrong, the attorneys. Well, as the evidence unfolded, there I was, the young advocate in this team. David Soggett would send me into Alex and say, go and find witnesses. the state would say at such and such a day, at such and such a place, there was a treason plans were being hatched. And David would say, Margie, go and find a witness who will gainsay that. And believe you me, Chris, who lived at 7th Avenue, Alex, those of you who know Alex, he would accompany me, and we would walk the dusty streets of Alex looking for witnesses, and believe you me, we found them. Those witnesses would say, I was at that meeting, there was no treason. I didn't have to prompt them. They would say, well, we spoke about the streets, the lack of toilets, the lack of water, etc., etc. And those young people that faced the death sentence, they were acquitted of treason. And Advocate Ntambela, don't report me to the Bar Council, this advocate going into a community finding witnesses. That's something that advocates didn't do. But those were tough times where treason, if you were convicted, you faced the death sentence. Now, we see how far we've come. There's another case, and this is the last example I'll give you. In the town of Komani, Queenstown, in the Eastern Cape, where I come from, 7 young men were sentenced to death, and that was in the 80s. There was no constitution then. Makanyane was still a far dream. And we managed, just by saying that nothing is impossible, we managed to get those 7 young people off death row. So, you know, young people in our audience, don't be impatient. In 30 years, there's been a quantum leap. And I'll just give you examples of this quantum leap, what has occurred as a result of judicial review. The death sentence ended. Presidents are held to accountability. Marriage equality. The courts are focused on parliamentary processes, looking at decisions made by ministers. There's now educational equality. The freedom to love. Everybody's rights counts, from citizen to prisoner, to sex worker, to biological father, to foreigner, to trust beneficiaries, the homeless, the land claims that we've heard so much about today. And the justice for mine workers, the rights of victims in the parole process. And then there are 3 ideas that I want to leave you with, and this is, I hope, going to be relevant for the next 100 years. Dr. Fraser Moleketi mentioned that it was 100 years ago that women were admitted to the legal profession, and we celebrated that last year. But let's see what we're going to celebrate in 100 years' time. That will be 70 years from today, from the 21st of March. Let's hope that our young people will carry that forward, the kind of transformation, constitutional transformation, that must still take place. But the 3 concepts I want to leave you with, and that is Ubuntu. Nicolene Turon, when you mentioned Ubuntu, it went straight to my heart. I've written some judgments on Ubuntu. But as our president said, colonialism brought with it the destruction of our indigenous legal system. And for hundreds of years, Ubuntu worked so well in Africa, but came the colonialists, and then they imposed that Western concept of jurisprudence. But let us never forget about Ubuntu. If that can just be at the forefront, a lot will be achieved in the next 70 years. The other legal instrument that is so important, and that is intersectionality. Samai is going to talk about intersectionality and what a difference that legal instrument has made in our jurisprudence. The other last aspect that I want to talk about, and that is contractual sophistication. We are complexifying everything. I think that was what the lead speaker said in the last session. Contractual sophistication is something which a dominant party imposes on the consumer. And really, that is something we've got to look at. We've got to look at someone concluding a contract in legalese, in English, which may be their third or fourth language. Another lead speaker, moderator, said, there's Bioscope, there's a video. You know how easy it would be to have a video or some pre-recorded message before consumers sign agreements, so they understand exactly what they're letting themselves in for. So there you are. There are enormous challenges for the future. And in conclusion, I want to say that very often there is a tension between the state and the judiciary. But I see it as a very constructive tension, because at the end of the day, it is the citizen who has a win-win situation. Not only the state wins, but the citizen does as well. So that tension, let it be constructive as it has been, and I hope for the next 70 years to mark the 100th anniversary, it will continue to be as constructive as it is. Thank you.
Thank you very much, Judge. If I could invite next Romeo Ntambeleni, SC, a member of the South African Society of Advocates, and somebody who knows an awful lot about administrative law.
Thank you. Thank you. Good afternoon, distinguished ladies and gentlemen. Honorable President Ramaphosa in absentia, Honorable Minister Lamola, the DG, Doc Mashawan, the members of the judiciary who are now present, all of them. I see that they are my three bosses that are present here, two from the Western Cape, and Deputy Judge President Lidwaba as well. So for the sake of time, I'm not going to repeat a lot of things that were said from the message of the Chief Justice about the realization of the goals that the Constitution has achieved in the past 30 years. What I'm going to zoom into is Section 172 of the Constitution that talks about review and the power of review that is granted to us by that Section 172, which has been used in many lawfairs that actually has outplayed itself in our courts. It's true that the judiciary don't make cases. They don't create cases and bring them to the court. Cases are brought by the litigant, and when the litigant brings the cases, the judge's function is to actually adjudicate on those matters. So Section 172 of the Constitution makes provisions for judicial review of legislative actions, and we are aware that the final arbiter and the final decision maker in relation to constitutional matters is the Constitutional Court under Section 172(2), after court of the similar status being the Supreme Court of Appeal, and the High Court has taken the decision. So that is done with the power of accountability, which comes with the function of the courts that has been granted by the Constitution, as the Chief Justice has actually said. There's a lot of accountability in the judiciary, and you have already seen what is actually transpiring in relation to accountability in the judiciary. So the notion of saying that who will judge the judges or judges cannot judge themselves is false, and it's not true. We have seen when we were dealing with previous matters, there was issues relating to a vote of no confidence against the president in the matter of United Democratic Movement versus the Speaker of National Assembly, the 2017 matter. And there was also seminal judgments of Federal Life Assurance, LTD, versus Greater Johannesburg Transition Metropolitan Council. And there was a critical matter, the suffering matter, which dealt with the President's appointment of the Commission of Inquiry. And everyone will remember that our former President, Nelson Mandela, was brought to court. And that was dealing with Section 84(2)(f) of the 1996 Constitution. And through his exemplary leadership, he appeared in court, and we all know that that became a significant judgment as well. And then there were other matters like pharmaceutical manufacturers case, which dealt with the President's decision, how we can classify an administrative action as well. And then there are administrative actions that are done under Section 3 of PAJA. PAJA is very much important. The President has spoken about it earlier in the morning as well, and he referred to PAJA. And the matter that comes to mind is the matter of Democratic Alliance versus the Minister of International Relations and Cooperation, the 2017 matter that became popularly known as the al-Bashir matter. We remember what actually happened in that matter. It went up to the Constitutional Court, which came from the Pretoria High Court as well. And there are other decisions such as Earthlife, Johannesburg, and another versus the Minister of Energy, which also dealt with issues pertaining to review. So we are in a good place, and we are moving forward, and there is accountability, and the Constitution has safeguarded all these institutions so that we can be able to progress. And the judiciary has been doing a sterling job in the past 30 years to make sure that there is advancement of the balance of powers, also respecting the separation of powers doctrine that is central in all these issues. I thank you.
Thank you so much. I'll now be joined at the podium by Megan Finn, who is a senior lecturer at the Department of Public Law at the University of Johannesburg.
Thank you so much. It's really a big honor to be included on this panel today as we reflect on the past 30 years of constitutional democracy and the path forward. I've loved hearing all the speakers today and the other panelists reflect on the judiciary's role in ensuring accountability and protecting human rights. And I look forward to the audience's questions and engagements. In the time that I have, and I know it's late, I promise to try and keep to it, I want to reflect on two important and emergent themes which show the role played by the judiciary in vindicating rights and holding duty bearers accountable. The first is about the constitutional role of private parties in realizing rights. And the second is about how courts, in ensuring accountability, have sometimes had to resort to remedial resourcefulness to vindicate rights. So turning to the first theme, historically, constitutions have really been understood as governing the vertical relationship between subject and state, rather than horizontally between private persons. This is animated by the premise that individuals in private relationships exercise parity or equality of power, and by the public-private divide, which has been recruited to insulate private relationships from legal scrutiny, at least to a certain extent. However, in South African law, that premise now with our constitution has been interrogated, in part as a result of the gaping inequalities that are the legacies of colonial apartheid and patriarchal oppression. For centuries, the state and social norms more generally put in place the most stark, pernicious forms of discrimination. Apartheid was characterized by the deepening and expanding legal legitimization of discrimination, perpetrated by both state and non-state entities. Against this backdrop, and the extensive and sometimes coercive power wielded by private non-state actors, the South African Constitution marks a shift away from the premise that private persons always exercise equal power and that constitutional obligations should bind only the state. There is now increasing recognition that abuses of private power can threaten human rights just as violations by the state do. And although the state is the primary duty bearer of constitutional rights, South Africa's constitutional scheme envisages that private persons can bear constitutional obligations too. And this is particularly important, I think, given the trend seen across the world of privatization and the enormous and sometimes worrying role of multinational corporations. So how does the constitutional scheme regulate private parties? I'll speak about 3 important ways that it does. First, Section 8 of the Constitution governs what is called horizontal application. Basically, the idea that the Constitution does not only apply vertically, but can also apply horizontally in certain circumstances, and sometimes not necessarily in the exact same way that the duties apply to the state. There have been a number of recent and significant judgments where we see this playing out. In the Pridwin judgment, a private school was held to have duties in terms of the right to basic education in Section 29 of the Constitution, which meant that it could not simply end the contract with learners without giving them due process. This was tied to the important constitutional role played by private parties and private schools in particular. In King and Wilkinson, the Constitutional Court, in a number of judgments, including Judge Victor's own, held that the right not to be discriminated against unfairly, which had previously been expressly recognized in the public sphere, also extends to private testamentary decisions into private wills and trusts, which discriminated against beneficiaries on the grounds of gender and sex, in King, and birth, precluding adopted children from inheriting, in Wilkinson. These are both examples of how substantive equality demands regulating both the public and private sphere. Section 392 of the Constitution, 392, gives courts the power and the duty to develop the common law, judge-made law, classically like the law of contract or delict, succession, as well as customary law, to bring it in line with the spirit, purport, and objects of the Constitution. Judgments have used this provision to develop both the common law and customary law, and sometimes to extend and impose duties on private parties through existing but developed legal principles. And third, the understanding of public power in the constitutional regime, both in terms of the definition of administrative action in PAJA, our legislation that governs administrative law, and also in terms of the principle of legality, which means all public power must be exercised lawfully. That understanding of public power is a generous one. Importantly, courts have recognized time and again that public power can be exercised by both state actors, but also private ones. This is clear in instances where the state contracts with a private entity to fulfill constitutional obligations, such as in the significant all-pay litigation, which I will turn to again in a moment, where the state awarded a tender to a private company to administer the payment of social grants to over 17 million beneficiaries. In that judgment, not only was the private party found to exercise public power, but the Constitutional Court in fact went further and found that the party was an organ of state for the purposes of performing these functions. These cases are really significant. They show a constitutional commitment by the courts to regulating all forms of power, and therefore also protecting against possible abuses of that power. Although they leave open some important questions that us academics like to quibble about, including some theoretical ones, and others about how we understand the Constitution's relationship to the law that existed before it came to be, they powerfully show how courts work to protect and vindicate rights, and to ensure that duty bearers all around, both the state and private parties, are bound by the Constitution's demand. I'm now going to turn to the second feature, remedial resourcefulness. And I will use the last few minutes of my presentation today to reflect on an important, if sometimes troubling, trend of the past decade or so. This difficulty was vividly demonstrated in the all-pay judgment and its sequels, that social grant payment system judgment that I referred to earlier. So over the past decade or so, on a number of significant occasions, courts have been confronted with a significant and serious question. What should a court do when the government is required to take particular steps, as it often will be, especially in the context of positive duties under Section 7.2 of the Constitution and socioeconomic rights, but the government actor does not comply with these duties? And this phenomenon is even more acute when a government actor fails to comply with an existing court order. Now, this clearly places courts in a difficult position. How should courts deal with difficulties of sometimes systemic dysfunction, a lack of resources or capacities, or even non-compliance in the state? How should courts balance the institutional constraints on their powers with the public interest? This raises some obvious questions of the rule of law, as well as some profound institutional legitimacy questions for the courts. One very noteworthy way that we've seen courts responding to this dilemma is through what I call remedial resourcefulness, where courts use the power in terms of Section 172 of the Constitution, which Romeo shed light on earlier, to provide just and equitable relief as part of both ensuring accountability and protecting rights. And we've seen this trend in a number of instances of remedial innovations, with some important examples of courts taking increasingly interventionist approaches in their court orders, which become more detailed and sometimes more prescriptive. Turning again to the All Pay and Black Sash judgments, which again arose out of an unlawful tender award for the administration of the system of social grants. This had been awarded to a private entity, but there were irregularities, so the tender was declared unlawful. But there was a risk to the 17 million beneficiaries of social grants if the tender award was then also suspended. So what should the court do in this situation? How should it set aside the tender, or at least declare it to be unlawful, without then imperiling those rights of the beneficiaries? And the Constitutional Court crafted a remedy requiring a new tender process be run to uphold the rule of law, while requiring the private party in question that had been awarded the tender to continue paying the grants. This meant that the private company, functioning as an organ of state, could not simply walk away. And later on, in the face of the relevant government entity saying to the court that it was ready to take over the system of administrating these grants, when in fact it unfortunately could not, the court then had to deal with this again in later litigation. Black Sash had approached the court to protect beneficiary rights, and the court had put in place structural interdicts requiring reporting and also officials to account in their personal capacity. So we see there a cascading remedy, and quite an extraordinary one, born out of extraordinary circumstances and the need to vindicate and protect these important rights. This suite of litigation really demonstrates remedial resourcefulness by the courts and the judiciary's role in ensuring accountability and ultimately vindicating rights of those who are vulnerable. But of course, it comes with institutional anxieties, including the question of the appropriate role of judicial deference. True, courts have legitimacy in giving content to rights and ensuring accountability, but they are not and should not be the only branch of government to give effect to these important values and to realizing rights. There are also complex questions around a system of judicial review that gives oxygen to, rather than stifling, an efficient administration, while still, of course, ensuring that the rule of law is upheld. And the questions raise institutional concerns around the court's expertise in determining polycentric or policy-laden decisions, especially relating to the distribution of state resources, and then ultimately about the trend of what has been dubbed lawfare and the judicialization of politics. At the same time, of course, we know that courts play a vital role in vindicating rights, particularly as the social grants saga vividly demonstrated in the context sometimes of some dysfunction, where the stakes could not have been higher. And it is crucial that this continued role of the courts be protected, not only for, as the session's title suggests, purposes of accountability, but really as part of the life force that sustains our democracy and the fundamental rights that our constitutional democracy protects. So what does the road ahead look like? I think the Constitutional Court has said it best. In another judgment involving remedial resourcefulness and reflecting on the previous panel, the question of land reform and land justice, the Mwelase judgment. And there the court said that when we think about the role of the courts and separation of powers in our constitutional democracy, as well as the court's relationship with other branches of government, it is important to view this as a productive, mutually reinforcing relationship bound together by a fundamental commitment to the Constitution. For the courts and the government are not at odds about fulfilling the aspirations of the Constitution, but instead share a common goal and commitment to justice, dignity, and equality. I think I'll leave it there, but really looking forward to engagement in the later part of the session. Thanks.
Thank you so much. It's a phrase I particularly like, the judicialization of politics and the politicization of the judiciary. It's a great summary of the challenges of administrative law. Finally, I'd like to welcome to the podium Siham Samai. She is the director at the Women's Legal Center, and I think certainly the Constitutional Court is very familiar with her and the Women's Legal Center and the role that they play in advancing the right to equality. Thank you very much.
Good afternoon, greetings, Molweni, Assalamu alaikum. It's really an honor to be here today, like my other speakers have also indicated. But I just want to acknowledge the Minister of Justice and Constitutional Development, Minister Lamola, and all other ministers that are here, the DG of the Department of Justice and Constitutional Development, DG Mashabani, and the heads of courts, and also the judiciary. As an African feminist legal center committed to advancing the rights of women through substantive equality, the Women's Legal Center has been at the forefront of empowering and advocating for women's rights in our society. In relation to our topic today, there are many who have written on the role of the judiciary in South Africa and its role in interpreting and applying the Constitution. There is a clear understanding of separation of powers in these discussions and an acceptance that Parliament makes the law while the judiciary applies the law. This is a delicate balance of the rule of law, and although many believe that it's a collision course between the spheres of government, it is not. It is not meant to be a collision, but a careful dance where each uphold their roles and their responsibilities in the democratic and the constitutional dispensation. The concept which the judge has indicated, which is intersectionality, which was first coined by Kimberly Crenshaw, aptly captures the interconnectedness of various social identities such as race, ethnicity, class, sexuality, and disability. In the fight against gender discrimination, understanding and acknowledging intersectionality is paramount. It allows us to recognize the different struggles faced by women from marginalized communities who may encounter compounded discrimination and violence due to the layers of identity. In the case of Bashlango, which dealt with a domestic worker that took on the policy of government for not including them in the occupational injuries, and although Mashlango was not a legal review in terms of the legal process, it was a review of government policy where the court applied an intersectional lens to find it unconstitutional. Administrative justice serves as a cornerstone of equitable societies and ensures that individuals are treated fairly and justly in their interactions with administrative bodies. It's framework that upholds principles of fairness and transparency as well as accountability. And as we delve deeper, we begin to understand how administrative justice intertwines with the quest for women's rights and equality. In this presentation, we will delve into the intricate relationship between administrative justice, intersectionality, and the promotion of women's rights by shedding light on the transformative work of the Center in advancing equality through strategic litigation, advocacy, and partnerships. So how do we navigate the intersection? The intersection of administrative justice and equality is a nexus where the total battles are fought to dismantle systemic discrimination. Administrative decisions impact every facet of women's lives, from reproductive rights to workplace equality to protection from gender-based violence and access to social services, as well as access to land. So this intersection is precisely where we situate ourselves and towards pushing for a more just and inclusive society. Ruth Kolker raises the question of whether one can be a feminist and use the courts and litigation to advance a feminist intersectional lens or perspectives. She points out that while we often hear about the feminist position on specific issues, we really know how to do it and to effectively use legal arguments from this perspective. In other words, whether legal means align with these goals and how to make legal arguments in line with these values. So feminist litigation, feminist intersectional litigation, refers to the using of legal strategies and arguments to address gender oppression and promote gender equality, and it brings a gendered lens to the matter. Anna Pallet emphasizes the need for a feminist voice in litigation. She argues that the law's historical treatment of women has been influenced by exclusionary, gender-based politics and stereotypes. And to challenge this, it is essential to confront and transform the legal discourse that marginalizes and erases women's experiences, as well as the most vulnerable. Pallet emphasizes the importance that the text discuss the compatibility of feminism with legal strategies and how this litigation seeks to challenge and reshape this discourse. They emphasize the significance of representing women's experiences authentically and challenging societal biases to achieve women's realities in a comprehensive and authentic manner to address gender oppression in all its forms. Intersectionality and underlying power dynamics. Due to our colonial and apartheid past, all issues will affect the poor, rural African women on multiple intersection grounds than it would for someone in a more privileged position. Looking at gender-based violence and femicide, for example, it is women that exist in spaces where there are higher acts of violence and slower police response, who will feel the brunt of an ineffective justice system. So intersectionality can be best defined as the intersection between gender and race and other categories of difference in individuals' lives, societal practices, institutional arrangements, and cultural ideologies, and the outcomes of these interactions in terms of power. Since there have been differences in terms on whether the concept of intersectionality is a theory, a reading strategy for feminist analysis, or a methodological approach. But for us, intersectionality is best understood as a conceptual framework from which to understand and articulate the multiple oppressions. When implementing intersectionality in a legal environment, it requires that the law and its impact are used in a new manner that places substantive equality at its foundation. A gender lens is therefore applied not only to the facts of the appeal, but the law itself and how it impacts as a result. Intersectionality further allows us to see that sexual and gender-based violence are not uniform or precise, and that no one woman experiences discrimination in the same way. In the Constitutional Court case of Social Justice Coalition versus the Minister of Police, the WLC participated as a fifth respondent. And it was essentially about how the formula used by SAPS in the allocation of police services is discriminatory against black and poor people on the grounds of race and poverty. WLC made submissions as to why sufficient weight to the nature and extent of violent crimes committed against women in the allocation of equitable police resources. This was important for us to bring the intersectional gendered lens to the Constitutional Court because women are the most affected by violence and crime. So an important element in looking at things through an intersectional lens is to consider the underlying dynamics and the lack of bargaining power that exists. Women in their varying identities can express discrimination in diverse manners. Women of all races have to navigate misogyny in the workplace, and it's conservatively estimated that 1 in 4 women will experience sexual harassment in the workplace at some stage. So black women have historically always been subjected to violence in labor environments, and which is farm workers, domestic workers, sex workers, refugees, and migrant workers. And it still occurs in many spaces where there is a lack of oversight and accountability. So a black woman experiencing sexual harassment in the workplace, who is the main breadwinner in the family, may not speak up about experiences for fear of losing her livelihood. So in order to address the many socioeconomic issues that pervade society, it must be done using this intersectional lens. The continued existence of patriarchal systems and attitudes hinges on the ignoring of the mistreatment of women. Worthy goals like ending GBV and decreasing femicide needs to be done to represent all women and not only a select few. However, as we confront these crucial issues, it is essential to remember that we must avoid a one-size-fits-all approach. Intersectionality compels us to understand the diverse needs and challenges faced by different groups. It is imperative that we apply this lens to the facts of the matter, as this will allow the court to reflect on the multiple ways in which sexual and gender-based violence discriminate against women on multiple grounds of their identity. So intersectionality is a judicial tool. When interpreting the facts and the legislation of a case, one must take a contextual approach. Intersectionality is the interaction between different identities and cultural ideologies and the outcomes of these interactions. In the National Coalition for Gay and Lesbian Equality and another versus the Minister of Justice, the Constitutional Court indicated grounds of unfair discrimination can intersect, so that the evaluation of discriminatory impact is not according to one ground of discrimination, but on a combination of both. And then in Mahlangu, the court noted the power of an intersectional approach lies in its capacity to shed light on the experiences and vulnerabilities of certain groups that have been erased. So the importance of this as a judicial inquiry was investigated by Mahlangu. And in the case, it indicated that this is a textured analysis, an indispensable legal methodology, and using this framework as a legal tool leads to more substantive protection of equality. Adopting intersectionality as an interpretive criterion enables the court to consider the social structure that shaped the experience of marginalized persons. So how do you do this? So there's different methods, but I will highlight just three. There is the women's question, which involves critiquing the substance of law to identify gender implication. By using the women question, feminists seek to avoid unjust gender bias in a legal decision. So the method challenges how women have been excluded from legal consideration. The practical reasoning seeks to recognize diverse human experiences and considers perspectives not represented in the dominant culture. So it involves acknowledging positional partiality and making moral and political choices explicit. So this method reveals insight about gender exclusion within existing rules and principles. Conscious raising complements these methods, and it's a platform to bring marginalized voices to be heard. It involves an interactive and collaborative approach and sharing experiences. So in conclusion, by using these methods, feminists can change assumptions about women underlying various laws, and the Constitutional Court, in the case of Mahlangu, referred to this as an indispensable legal methodology. Adopting intersectionality as interpretive criteria enables the court to consider the social structures, and looking at state policy through an intersectional lens ensures that the rule of law benefits all. And just to be able to say, to embrace this as a judicial tool for just administrative action. Thank you.
Thank you so much, Saham. I would now like to turn to our audience and see if there are comments or questions. I see a hand waving there. Sir, you are number one. Do I have any other hands? Number two, over there. And let's take that as the first round. Please go ahead. Do we have the mic that side? It would be useful if you say who you are, although hi, Tsidiso. And then secondly, if the question is aimed at anybody in particular, just so that you can give them a heads up that they're the one you're gonna aim the question at. Go for it.
Tsidiso Tipanyane, South African. My question is really to comments, but I would like a response from the panel. That since we are here to reflect on 30 years of human rights and the role of the judiciary in terms of administrative review and accountability, my question really is, with the population of 60 million South Africans, are we doing really well in ensuring that the courts are accessible to our people in order for the courts to fulfill that role? We have a number of problems here. One, the courts are not very accessible in terms of legal costs. Not many South Africans can afford going to courts. Secondly, the language used in courts. How many people can read judgments written in English and maybe sometimes Afrikaans? Thirdly, the ambience of the courts. Should we also consider 30 years later of getting rid of the ropes in the courts so the courts can become more friendly? Fourthly, to what extent have we actually brought in African customary law as part of our legal system? If we really want the courts to play their role in holding the executive to account and providing justice. And I think we need to reflect this. 30 years later, how many of our people are able to use the courts for justice, as opposed, for example, to Mahotla, where people can just go and they trust their issues. Now, if human rights 30 years later are not improving in our country, is it not because, to some extent, the courts are not accessible? They're only playing a role for the elites and those who've got money, and not our people. Thank you.
Thanks, Tsidiso. Over there.
Thank you, Program Director. My name is Palesa Ledwaba. I am Managing Director at Maponya Attorneys and also member of the Black Lawyers Association. I would like to simply greet all dignitaries and observe all protocol of all dignitaries that are here under the leadership of the President and Minister Lamola. Mine, Program Director, is not a question, but more of a comment, but I do wish that the panel engages with this comment. I believe it was Dr. Frazier earlier on who mentioned the 1912 case of Woki, whereby the presiding judge at the time did not disappoint in his mandate to uphold the unjust laws of the time by refusing to grant an order to register the articles of the applicant simply on the basis that it was a female. I believe that it is with the same vigor and shamelessness that the judiciary of today should ensure that they restore the dignity of the Black people, not only through the judgments that they write, but also in their courts. And it is for this reason that I commend the likes of Judge Mota for the stance that he took recently in protecting the dignity of the Black people. Thank you.
Thank you so much. Tsidiso raised a number of issues: accessibility of the courts, the language in courts, the robes in courts, and then the actual substance of what the courts deal with. So looking at things like African customary law, which I think we would all acknowledge has been on the back foot, I think, in the courts in many instances. Who would like to have a go at that? Romeo, you start, and then Saham.
Thank you very much, Advocate Tipanyan. Our system is not perfect. We are very far from perfect. 30 years into our democracy, there's still a lack of access for courts for Blacks in South Africa. And these issues has been raised on a number of forums, not only by different judges. I remember Judge President Mlambo also raised it on a number of occasions in terms of accessibility of courts. Let's not forget that our constitution allows the traditional court system as part of the system that is supposed to actually be used. So we are very far from a perfect system that is representative, to each and every one. So I think also the minister is here, he's listening, and we will also make sure that, through other mechanisms, all those issues are actually addressed. And Ms. Lidwawa was speaking about restoring the pride of black people as the majority, in the society. I think that is important and that is critical. And we are all tired, in the past 30 years of not realizing the goals, that we are supposed to achieve in terms of the Constitution and what is written in the Constitution. And we are all of us asking questions to the very same Constitution that we are supposed to actually engage with to realize the goals that you are actually talking about, Advocate Tupanyani. You have been at the Human Rights Commission for the longest of time, and you are very much aware that there are many challenges that are being faced in the judiciary. The Chief Justice was speaking about the budget as well, that is given to the judiciary. Also, those things have an impact in relation to delivering access to justice for all. So I agree with you that it's for the limited few, and it is the responsibility of everyone who's actually sitting here that we have a progressive realization of those goals so that the Concord will move in the manner that it was moving when it was dealing with matters of treatment action campaign and all other matters. So I believe that we have a lot of work in our hands to make sure that we achieve that. Thank you.
Yes, thank you. Just with regard to the first speaker, we also need to acknowledge that there are also, for example, Legal Aid South Africa. There are various courts that has domestic violence clerks, maintenance officers, etc. And I know that all of this is obviously on paper, but is also physically. They are supposed to provide, for example, these legal services in these matters, which primarily faces women, which comes to maintenance, domestic violence, access and custody of children, etc. So, but still, the challenge with the courts is that we need to be able to understand it's still a very patriarchal space that does not acknowledge persons or will call other. And we need to be able to see how those court system embraces the marginalized as well as the vulnerable. So we need to be able to go deeper. We have the formal equality, we have the laws. We need to be able to do implementation and ensure implementation comes out with substantive equality. I hope that answers you. With regard to 100 years of women, the Wookie judgment, etc. And yes, there are still challenges within our system in terms of transformative judgments, but then there are ones that acknowledges, for example, the African black woman, that brings out the dignity of the African black women. And these cases are Bashlangu, for example, that speaks to that. We have the Buanya judgment that speaks to centering some of these challenges and bringing out the voice of women wherever they are. But it's far between. It's mostly in the Constitutional Court. What we need to see is it needs to go down to our magistrate courts. It needs to go down to our lower courts, where majority of our people are sitting in the divorce court, in the maintenance court, in the family courts. And so these judgment needs to filter down, and I do think that is some of the problem, that we need to be educated how these judgments came about and how do we center the African black women, within these particular cases. I hope I answered you. Thank you.
Right, perhaps I can comment on the Wookie judgment. There were 3 male judges. It was the Rose Innes Court at that time. And as Dr. Fraser Moleketi has illustrated this morning, a woman was not considered to be a person, but it went further than that. A woman, what Judge de Villiers said, he was one of the sitting judges, he said that there's not enough work for male advocates. Now we're still going to, and I'm paraphrasing, And now we're going to, why do we want women? They're going to take the work away from the breadwinners. That was Judge de Villiers. But, you know, I'm optimistic and I'm grateful that in these 30 years we have seen change for women practitioners. Okay, we haven't gone far enough, but I think Minister Lamola, you have, and the judges' presidents have really made an effort to make sure that women are elevated into leadership positions, that they are elevated onto the bench, and this has brought about a difference, an enormous difference, and also the confidence that the public has. But one day when you have time, read the Wiki judgment. It is terrible. They said women must stay at home and bear children. That's their biological and God-given role. They are emotional. They cannot deal with an adversarial process. I'm paraphrasing, but this is what it boils down to. They're far too emotional. They cannot read contracts. Now let's go to contractual sophistication. They don't know how to deal with complex contracts. So, to my audience, we've come a long way, and women lawyers and practitioners and judges have come a long way, but we do look forward to the next 70 years. Thank you.
And on the note of transformation, I'd like to tip my hat to the members of the JSC present who I think have been really firm and clear over many years about the importance of transformation and a transformative jurisprudence in our courts. Do I see any burning questions? I'm not sure that I do. In which case, Program Director, shall I come back to you and ask you to come up to the podium? And then if I can just thank all the panelists for their contributions. Thank you very much.
Thank you very much, Facilitator. In fact, you have handed us over back 40 minutes. We were scheduled to finish at 6:30, so that was very effective and efficient. Let's give the Facilitator a round of applause. Thank you very much. You'll receive packs of the 30th anniversary edition of the copies of the Constitution. I think the 50 that we printed due to budget is getting depleted. But there's one we must reserve for the chairperson of the LPC, Minister. We will be in trouble if the chairperson of the Legal Practitioners Council doesn't get one, so we'll reserve one of all that we have for her. You may be excused. Someone had come forward, Kotlan, for the glasses. I think there was a gentleman who came to inquire about the glasses, these ones, so he can get them. I think we have come to the end of today's program. Tomorrow we are scheduled to start from 8 with registration for those who are not registered, and coffee and tea will be available. At 9 o'clock, we'll start with the statistician general who will set the scene by giving us an overview of statistics over the past 30 years on socio-economic rights in general. And we'll immediately move to have a discussion on the economy. And I think that will be the most interesting discussion. So the first panel after the statistician general will have set the scene will be a discussion on the economy. But other than that, it's all left for me for today to thank Minister Lamola and his colleagues from Cabinet, members of the judiciary who are still here, members of the legislature as well that are here, particularly from our portfolio committee on justice and correctional services, and all the conference delegates that have stayed the course until now. We would like to adjourn the conference and release all of you to go and rest and come back fresh tomorrow. The General Secretary is here. I see he is flexing for tomorrow on the economy. So come prepared and expecting for a very dynamic discussion tomorrow. The conference is adjourned. Thank you very much.